All right, let me see how we looking up in here. We should be good to go. Back in the building. Shout out to everybody who's in here. Y'all know what to do. Drop a 1 in the chat if you can hear me. Drop a 1 in the chat if you can see me. We're looking all crispy and clean on the screen. And I have to welcome you. Welcome back to another YouTube live stream and another episode of the ClassE Morning Show. I'm your host, ClassE, of patreon.com/ClassEbeats. By the way, the link is in the description as well as in the pinned comment in the chat. And we are going to get into it. We're starting the day off with a sneeze. Oh my. The sneezing on the intro is a no-go, but hey, we still pushing through. We're back into the Donna Adelson trial, day 8. We're gonna see if Donna's gonna testify. Defense's case so far is going absolutely terrible, in my opinion, and we're gonna get back into it. We've got Donna's friend is gonna be back on the stand today, which is gonna be crazy. So either way, we're gonna get started here shortly, but I gotta say what's up to the people before we get started though. Oh my goodness, you know what time it is. We got my awesome, amazing Amy in here. First thing in the morning, always showing up and showing out to fly. We got Just Saying with Alicia, Slim Life. J Money, the big dog's up in here. Got to give him a round of applause. We got Les Cleaver in the building. We've got, who else did I see in here? We've got Erica. Good morning, Erica. Mayflowers is in here as well. We got Kelly Berg. Good to see y'all this morning. All right, we're going to go ahead and get into it. I'm not going to waste any time. If y'all could, please make sure you like the video on your way in. Not only are likes free, it helps the channel continue to grow, lets the algorithm know you guys are enjoying the show, and it shares the video, the channel, this live stream out with more people. So if you could, make sure you like the video. It takes less than a second. Also, if you're feeling extra generous, you can share the video as well. Just click the share button with the arrow pointing to the right. That helps out a lot too. You can share it on Facebook, Instagram, I mean, anywhere you're on social media. All right, and you can also even share it to your group chat if you click the option to share via text. Thank you to those of you who do that. I see y'all over there sharing out the video. I appreciate it, and it means a lot that y'all do that as well. Last but not least, I will be reading super chats as we go throughout the show. So big thank you to everyone who goes the extra mile and drops the super chat as well. Shout out to Vincent, who's asking about her friends. Her friend is actually gonna be back on the stand here today. Yeah, and Cunningham is back. In my opinion, one of the worst witnesses, the first witness called by the defense, and one of the worst witnesses we've absolutely seen. Your channel is the only one I see where the likes reach 600 in under 10 minutes. That's the love, man. Because I'd be up here begging for likes, right? You gotta beg for them. And Amy's up here reminding y'all every single show to like the video. Let me read some super chats so we can get into it. Les Cleaver has been a member for 11 months. Said it's been an amazing ride. Praise God. Amen. He also gave you guys a chance to be a member as well. Les Cleaver gifting 5 memberships. If you got a membership from Les Cleaver, please make sure you say thank you. He's giving you a chance to get your name highlighted in that beautiful green. You also get an opportunity to check out the members only content, and you get instant access to any video that we drop here on the channel, right? So shout out to Les Cleaver for that. He also drops the 10 bomb and says, today is a new day, a fresh start. Yesterday is behind us and God loves us despite our shortcomings. Amen. I pray each of you have a great hump day and the rest of week. God is great. Amen and amen. Thank you, Les Cleaver. We got Slim Life in here. It says, good morning, ClassE and fam. Have a great day. Surround yourself with people who inspire you to be the best version of yourself. Love y'all. Shout out to Slim Life. And then of course, my awesome, amazing Amy is up in here gifting 5 memberships. All right. So again, if you got a membership from Les, if you got a membership from Amy, do the right thing. Make sure you show them some appreciation and love and say thank you. All right. Cause they're giving y'all a great opportunity over there as well. This is going to be interesting. So we're going to go ahead and get into it. We've got a lot of court coverage to get into. So again, if y'all could, please make sure you like the video on your way in and we'll go ahead and get started with this. So we got to hear yesterday, one of the first witnesses, or the first witness from the defense in the Donna Adelson trial, Ann Cunningham. And her testimony was terrible. We saw the typical thing we see from witnesses that are lying. during her direct testimony with the defense, things were fine, running smooth. But when she got questioned by prosecutors, I don't recall. I don't know. This didn't happen. And then she seemingly even just ruined this entire case for Donna. The defense is calling her back, I guess, because they want a repeat. I don't know why they would call her back up here, but we're going to get into Ann Cunningham's second time on the stand, and we're going to hear from some other friends of the Adelson family as well. Here we go. Check it out. I guess they had to get her back in here to clear up some things.
Being previously sworn, I'm just going to remind you, you are to tell the truth in this matter. You may be seated, and at this point, you'll be examined. You may examine when you're ready.
Thank you. If you could pull that microphone down, Ms. Cunningham.
Oh, sure.
Thank you. I have a question about your use of cell phone service, and we touched briefly on things like WhatsApp, and what was the other one you said you use?
Viber.
Okay, Viber. When you communicated with Mrs. Adelson, did you routinely use one of those apps?
Quite often, yes.
Which app did you use mostly?
WhatsApp or Viber.
Okay, all right. And as opposed to picking up and using the cell phone service, you would use those instead?
Yes.
Okay, I don't have anything further.
Cross-examination.
So you had gone to the airport after your last testimony, right?
That is correct.
And returned to the courthouse?
Yes.
To tell us what, that you used Viber or WhatsApp to make
Yes.
that phone call?
Yes.
So it wasn't a regular phone call?
Correct.
Okay, so you misspoke earlier, or it just wasn't clear?
No, I said she called me.
Okay, and she called you and made a regular phone call on June 23rd, the month before
get your story
the murder,
together.
right?
I don't recall many. She made many phone calls.
And she called you on a regular line on July 20th,
Here
just
she
2
goes
days
with
after
the
the
don't- I
murder.
don't
Do you
recall.
recall that?
If you say so.
Okay, and July 21st,
The objection.
Yeah, the witness is not being shown the evidence that she's being confronted with.
I believe she is not
doesn't ask
asked,
you.
or she is not asked to recall, or let me clear this up. Ms. Cunningham, do you need to see the items that the state is referring to refresh your recollection?
Do I?
Would you
Yes,
like to see them?
if I spoke with her, I spoke with her.
Okay,
So
so,
she
you
said
have
no.
no reason to contest that you spoke with her via regular phone call, June 23rd, July 20th, and July 21st.
If it's on the record, yes.
But you're saying it was a WhatsApp or a Viber on the 18th.
Yes, they were in the car, and they often called on those apps in the car.
Would it surprise you to learn that WhatsApp didn't offer voice calls until March of 2015?
Then it was on Viber.
Must have been Viber, huh? Nothing further.
Redirect examination to the witness. You may step down, Ms. Cunningham.
Why did they bring this
We
lady
are certain
back,
she's been
man?
believed at this point. Have a safe travels.
Thank you.
Please call your next witness.
Defense will call Richard Shagran.
Yo, look at the demeanor. Body language experts. Where's Amy at? Look at the demeanor of this attorney. Look at this. What is going on with this defense team, man? Why she look like she just got told that she's not gonna get the toy she wanted for Christmas? What? She's sitting there. Look at this. It wasn't just for a second.
Please call your next witness.
Defense will call Richard Shagran.
Look at this. What's wrong? Yo, look at her and look how she's walking out of the courtroom. I didn't get the chatty Cathy. She big mad. Yo, this defense team is trash on this case. Wow. She mad she didn't get that chatty Cathy back in 1955. She thinking about that right now. This is all my dad's fault. It's tough. Who are they calling next? Said Donna wasted all that money. Goodness gracious. Why did they bring Ann back? Oh boy.
Good afternoon, sir. Please raise your right hand.
You got the walker and
Do
everything.
you swear or
everything.
affirm the testimony you
What's
will
up,
give today
Kelbo?
will be the truth?
I do.
You may take your seat. Please adjust the microphone as you need to.
Thank you.
And who is this fine gentleman here?
Good afternoon, sir. Can you please introduce yourself to the jury?
My name is Richard Shagran.
Mr. Shagran, how do you know my client, Donna Adelson?
I met them 37, 38 years ago.
Oh, he's
They're
known
best
for a long
friends. The wife was the president and CEO of a nonprofit. I was chairman of the board.
And
I think
you grew
it's
close with
G-R-A-N.
Donna and her husband, Harvey Adelson?
When I first met my wife 36 years ago, we formed a gourmet club, and they were part of the gourmet club. And we met probably every 2 to 3 months. And then
Oh,
as the
that's
years
cute.
progressed, we became friendlier and went on a number of vacations with them.
Okay, you say gourmet club. Is it?
Gourmet dinners at people's houses.
Now, are you married, sir?
I am.
Okay, and what does your wife do for a living?
She's an attorney.
What kind of attorney?
Specialty is real estate, estate, corporate,
Oh.
and bankruptcy.
Estate planning?
Yes.
Had an attorney friend.
Now, did you speak with Donna or Harvey on the day that Charlie was convicted?
No.
How about the next day?
Yes.
Without telling us what they said, did you and your wife go to their residence in Miami?
Yes.
Okay. And when you got there, can you describe Donna for us?
She was distraught.
And what about Harvey?
Oh,
Harley was like in shock.
that's sad.
Now, prior to this, you indicated that you had traveled with my client and her husband. Did you travel extensively on your own?
Well, we went on cruises, and then we did there was 13 of us did, I guess, 2 weeks in Israel.
Okay. Were you somewhat savvier than they when it comes to booking travel?
Oh, yeah, I've been to 75 countries around the world.
Okay. And were you
Wow.
asked to
That's a lot.
assist them in any way on November 7th of 2023?
Yes.
And specifically, what were you asked to do?
Initially, I helped Donna with the visa. And then when we were done applying for the visa, Donna took Susan to show her the dress that she bought for Lincoln's bar mitzvah. And then she asked Harvey to sit down with me and make plane reservations.
Okay. When you sat down to assist with the reservations, what did you discover?
The ironic thing was that the round trip was a fraction more than one way, and I suggested, since you don't know when you're coming back until sometime in January, book a one-way. And I remember commenting to Harvey, I said, I'd be willing to bet it's cheaper to fly from Vietnam to the United States than it is from the United States to Vietnam.
Now, let's back up a little bit. Let's talk about the
I'm not
visa.
buying it.
Were there options that were given when selecting which visa to apply for?
To my recollection, there was only two options, a 30-day or a 90-day.
Do you know why the 90-day was selected?
Well, I said they didn't know how long they were going to be gone.
And
I'm not buying it.
do you remember if the visa that was applied for only allowed them to come into the country once, or did it allow them to come into the country multiple times?
I'm not aware.
Now, you indicated that they were coming back for their grandson's bar mitzvah?
Yes.
Okay. Why, if you know, why were they wanting to get out of town?
Well, unfortunately, they were barraged by the media. Unfortunately, they live in a condo, so they didn't let them in. And they were afraid to leave the building.
To your knowledge, had the Adelsons been to Vietnam in the past?
Yes.
And they found it to be relaxing?
To my knowledge, I was there. I thought it was a great country, great people, great food.
Now, although you are the one that suggested the one-way ticket, who booked the flight?
Harvey.
To your knowledge, were they free to travel?
They told us when we got there that their attorney said they had no restrictions in traveling.
Can you describe the type of mother and grandmother that you observed Donna to be?
Well, Donna was the ultimate Jewish mother, not unlike my wife, that was very involved in their children and grandchildren's lives. I think Donna maybe was a little more involved in her grandchildren because of the situation of grandsons losing their father, Wendy
I think he's telling
working,
the truth,
and
too.
also they live close by, Donna and Harvey in South Beach.
So, am I hearing you correctly? You would describe Donna as a typical Jewish grandmother
More than typical,
and a typical Jewish mother?
yes.
At the time that you were assisting them on November 7th of 2023 with the travel, had they decided when they were coming back from Vietnam?
They were undecided, other than the fact that they were going to, whether it was prior to the bar mitzvah or just before the bar mitzvah, they didn't know how long they were going to be gone.
But they were coming back for the bar mitzvah.
Oh, definitely. They wouldn't miss it for the world.
Just a moment, Your Honor.
Oh man, somebody said in the chat, are these character witnesses or have they provided any evidence? No.
Right, and so what we have ultimately is that there is no evidence, none.
It's like, hey, oh yeah, Donna was nice. Oh, of course they were planning to come back. Well, this is what she told me. That's fine, but we have evidence to show something else, not just your conversation with your friend Donna. Get out of here. I am not buying the fact that, oh, just book a one-way ticket and then get a ticket while you're in Vietnam. Okay, does that make sense? Yes. Given the other evidence surrounding this, was that the only reason they would book a one-way ticket? No. Doesn't look like it to me. What do y'all think?
Sir, at the time that the travel was
Come on,
booked, the bar
Georgia.
mitzvah was
Dice
less
is
than
dude
90
up.
days away, right?
It was in January.
Do you recall giving a deposition? It was by Zoom, but I was present, August 29th, 2024.
Vaguely,
And in that deposition, weren't you asked, so did you make any of the decisions when to travel or how to travel, or were you just the conduit to the technology? And your answer was the conduit for the technology.
yes.
But today you're saying you're the one that suggested that they fly one way.
Objection, Your Honor. Improper impeachment.
What?
Rule,
Isn't that
Overruled,
right?
dude. Improper
Well, to me,
impeachment.
that's part of being the conduit, just suggesting.
You were there because you
Improper
were more computer
impeachment?
savvy than Harvey or Donna, right?
I was there that day.
Yes, sir. To help with the computer is what you said in the deposition.
Well, once we got there, I was there because my wife had done estate planning for them.
Okay, but what you did in reference to the travel planning was help with the computer,
Yes,
because you were more computer savvy than these two.
correct.
Okay. But today you're saying you suggested the one-way flight, right?
I just offered my suggestion.
Okay. And you said that Donna Adelson is a typical Jewish grandmother. Does a typical Jewish grandmother suggest dressing her grandchildren up in Nazi uniforms?
Not to my knowledge.
No further questions.
your right to examination.
Thank you, Your Honor. Would you say that you are more travel savvy than Donna and Harvey Adelson?
I would say yes.
And when you were deposed on August 29th of 2024, did Ms. Kappelman ask you if you made any suggestions about a one-way ticket or a round-trip ticket?
I don't remember.
Would it be helpful if I showed you a copy of your deposition transcript?
Surely.
I'm going to show page 11, lines 12 through 17.
You want me to read which one?
If you could just read page 11, which is where you're on, lines 12 through 17.
12, question, okay.
To yourself.
Oh, I'm sorry. Okay,
Did Ms. Kappelman ask if you made any decisions?
no,
Well, she asked if you made decisions, but you did not make decisions, did you?
no,
You made suggestions.
yes.
Nothing further.
Get this guy out
Does
of
this
here.
witness need to be retained or is he released?
He's released, Your Honor.
Have a good day, sir.
Thank you, sir.
Yeah, I mean,
Please call
what
your
was the
next
point of that
witness.
testimony?
The defense would call Terana Khan.
Who do we have up here next for this? Whatever the defense is doing right now. How are y'all feeling about this case that the defense is presenting? Look at man, poor Richard had to sit down to take a break before he goes out the door. Of course, he's sitting down right next to Harvey. That's cute.
Please raise your right hand. Do you swear or affirm the testimony you will give today will be the truth?
I do.
You may take your seat. Please speak loudly and clearly for the jurors. You can adjust the microphone as you need.
Thank you, Your Honor. Good afternoon. Can you please introduce yourself to the jury and spell your last name?
Yes, my name is Terana Khan. Last name is Khan.
And Ms. Khan, how are you employed
I spelled Terana.
currently?
I'm a mitigation specialist / paralegal for the Federal Defenders of the Middle District of Georgia.
And what is that what do those job responsibilities entail?
What I do is
No,
I
I spelled
go
it wrong.
on, I go down 3 different, the male side and the maternal and paternal side of the families, and I investigate all of the issues. I don't do fact investigation, and I also do the mental evaluations not the evaluations, but I go back, doing all the records and get all the things together, present it to the courts, so we can try to get a lesser sentence for our clients.
Okay. And that's with a habeas unit?
Not right now, I'm just with the Middle District of of Georgia, but I was doing that with the habeas here in Tallahassee.
Okay. And how long have you been in your current role in the Middle District of Georgia?
1 year in Georgia.
Okay. Prior to that, did you work for the Federal Defender's Office here in the Northern District of Florida?
I did the Capital Habeas Unit.
And can you tell us what you did there, please?
Yes, I did investigation, went to talk to clients, all their families. It was more of a fact investigation at that point.
Okay. And so that entailed you going out at the direction of the attorneys that you worked with, interviewing individuals,
Correct.
gathering records,
Yes.
and that included individuals that were in custody, correct?
Correct.
And preparing reports
Correct.
and presenting that to whom?
The attorneys.
Okay. Did it also bring you to have occasion to testify in court ever?
No.
No. Now, how long were you employed with the Northern District of Florida Federal Defender's Office?
From 2016 until July 2022.
And can you tell us a little bit about your educational background?
Yes, I have an associate's in paralegal, a bachelor's in legal studies, and I've studied sociology, and I've earned a certificate in that.
Okay. And when did you complete your bachelor's?
In around 2014, maybe?
Okay. Now,
Sometime.
in
What's that
between
take?
working for the Federal Defender's Office in the Northern District of Florida and the Federal Defender's Office in the Middle District of Georgia, did you work as a licensed private investigator in Florida?
After I left the Federal Defender's Office in Tallahassee, yes.
Okay. And how long did you do that for?
Since 2022, and I never stopped. I just took the job for the Federal Middle District of Georgia and left.
Okay. And as a licensed private investigator, were you retained by my office to interview an individual by the name of Patricia Bird?
Yes,
And where was she located?
in the Leon County Jail,
Okay. How many times did you meet with Miss Bird?
once.
And that was at the Leon County Jail?
Yes.
And do you remember when that was?
I want to say January. Can I look?
If it'll help refresh your memory,
Okay.
sure.
Ms. Bird was on January 24th.
2025?
Correct, sorry.
And when you interviewed Ms. Bird, did you tell Ms. Bird that Mrs. Adelson was going to pay her for her testimony?
No,
Specifically, did you tell Ms. Bird that
Of course
Donna
you didn't
Adelson was
say
going
that.
to buy her a piece of land?
no,
What about a trailer?
no,
What about veneers for her teeth?
no,
What about a small vehicle for her and her children?
no,
Okay. Did Ms. Bird tell you that Mrs. Adelson had offered those items to her?
no,
Did Ms. Bird tell you that Mrs. Adelson confessed to any portion of the crimes with which Mrs. Adelson is charged in this case?
Did she tell you that? I'm sorry, can you read that
Did
for me?
Ms. Bird tell you that Mrs. Adelson confessed to her?
No,
Yeah, she's probably keeping that in the bank.
Just a moment, Your Honor.
She wasn't gonna just tell anybody. She had to make sure she was gonna get something out of it first. Come on now.
Ms. Kahn, prior to interviewing Ms. Bird on January 24th, 2025, did you meet with or speak with Donna Adelson?
no,
Have you ever met with or spoken with Donna Adelson?
no,
Nothing further, Your Honor.
Cross-examination.
What are we doing here?
Why did you interview Miss Bird?
I was given a list of names to interview.
By defense counsel?
Correct.
Okay. And she was not a state witness at that time, right?
I wouldn't know.
Wouldn't know. Would it refresh your memory to see a copy of the state's amended discovery when we did list her as a witness?
I didn't see that. I wouldn't have seen that.
Okay, so
So
that
she's
wouldn't
saying
help
she
you
had
to
no
know
idea.
when she was amended as a witness in the case?
I wouldn't have known it. No.
Okay, so you were not asked to go there because she was a state's witness. I'll just put it
No,
that way.
no.
All right. And did you record your interview with Ms. Bird?
No.
The SAO investigators were able to record their interview with her. Why didn't you when you interviewed her?
I wasn't asked to do that.
Asked by who?
The attorneys.
So they didn't ask you to do it?
They didn't ask me to record it, no.
Okay. Could you have taken a recorder and recorded it though?
Had I requested for the jail to permit me to take a recorder in there?
The jail does allow that.
I
If
don't
you-
know, I didn't
if you
ask.
get, okay. If you get permission in your experience,
So
is it
why is she-
typical for
Correct, yes.
jails to allow you to do that?
Yes.
Okay. Just a second. That's all I have. Thank you.
Redirect examination.
Ms. Collins, since you didn't ask for permission to take a recording device into the jail when you met with Ms. Bird, how did you take accurate notes?
As I
She
was
wrote
speaking
them
with them,
down.
I wrote everything down that they said, that they were saying to me.
Okay.
So I did
Nice.
pen and paper.
Pen to paper. And had the state requested those through the discovery process, you would have been able to produce those.
Correct.
Nothing further.
Will this witness need to be recalled or retained for any reason?
We retain her, but she's free to go about her business.
You may step down, Ms. Khan. If you are recalled by the attorneys, they will let you know. Do not discuss your testimony with any other person. Please call your next witness.
Doesn't make sense.
Eddie Barnes?
He said Eddie Barnes. What do y'all think about that last testimony? It looks like most of you were saying that was pointless. And shout out to CPE. We might have a couple experts for the defense. Let's see who this gentleman is.
Do you swear or affirm the testimony you're about to give will be the truth?
I do.
You may take your seat.
Thank you, sir.
Please adjust the microphone as you need to.
We'll do it. Okay.
Thank you. Good afternoon, sir. Can you please introduce yourself to the jury?
Yes, my name is Eddie Varnes. Excuse me, E-D-D-I-E. Last name V as in Victor, A-R-N-E-S.
How are you employed, sir?
I'm a private investigator.
How long have you been a private investigator?
I've been a private investigator on my own for 10 years. Prior to that, total 27 years.
I can't do it.
27 years as a private investigator?
Yes, 27 years as an investigator. The last, yes.
This guy likes repeating questions a lot. Bro, what are you doing? He asked him a question. 27 years and we're having a crisis. Come on, man.
What type of casework do you handle?
Mostly criminal at this point in time. I also do insurance, civil stuff and insurance, but I've been exclusively pretty much criminal for about the last 10 years.
How do you get your work?
I market. I have my own company. I try to market and get work, and that's how you do it. That's all I can say.
Were you retained as a private investigator by Mrs. Adelson's original attorneys?
Yes, sir.
And when was that?
May of 2024.
Now, I want to specifically direct you to when you were asked to speak with an individual by the name of Patricia Bird.
Yes, sir.
Do you remember when that was?
That was August 30th, 2024.
Okay. And what did you go to the jail to meet with her?
Yes, sir. I received a call from prior defense counsel saying there may be a person that has information on the case. He gave me the name, so at that point I had traveled to Leon County Jail, got there about 11 o'clock, and then was able to meet with Miss Bird.
Okay. Now, there are different kinds of visits that you can do at the jail. How did you meet with her?
I met with her in an attorney booth.
Okay, so you don't need to schedule an appointment for that?
No, sir.
Okay, just normal business hours?
Yes, sir.
And tell us, without telling us what was said, how did the conversation go?
Basically, I met her and I introduced myself and explained to her who I was. And I said, you understand you might have some information on the case? And she said, yes.
And she might have some information on Donna Adelson's case?
Yes, sir.
Okay. What did she have information about?
She told me she had some information about what Katie McBanawa had stated to her back in 2021 when they were incarcerated together.
Now, did she tell you that Donna Adelson offered her any sort of compensation to testify in her case?
No, sir.
Okay. Specifically, did Miss Bird tell you that Donna Adelson offered to buy her a piece of land?
No, sir.
Did Miss Bird tell you that Donna Adelson offered to buy her a trailer for that piece of land?
No, sir.
Did Miss Bird tell you Miss Adelson offered to buy her a vehicle?
No, sir.
What about veneers for her teeth?
No, sir.
So she didn't tell you any of those things that she is saying Donna Adelson offered?
Absolutely not.
Did she tell you that Donna Adelson confessed to her?
Absolutely not.
Did you record your interview with Miss Bird?
I was instructed by prior defense counsel to not record the interview. That wasn't unusual because we spoke to I spoke to several prior inmates throughout those 2 or 3 months. So to answer your question, no, sir, I did not record the interview.
Now, did Miss Bird talk extensively about Miss McBanawa?
Yes, she did.
Did she say that Donna Adelson told her to say those things?
No, absolutely not.
Did Miss Bird know who Donna Adelson was prior to meeting Miss Adelson?
No, she did not.
Had she heard the name Donna Adelson?
No, she didn't. She actually told me when she met her.
When
in the jail, like she never heard of Donna's name. At that, she met her like maybe 4 weeks earlier inside the jail at that point in time.
Now, when Ms. Bird is telling you about Ms. Magbanua, did you caution her in any way about her cooperating on Donna's behalf?
Yes, sir, I did. She told me what she told me, and then I said, Ms. Bird, you know, the state's going to, you know, if you're a potential witness in this case, you're going to be put on the stand. They're going to say you were given something to say this. Our client told you to say this. And she said, absolutely not. They can say that all they want. That's the truth.
Did Ms. Bird tell you that Donna told her to say anything other than what was true?
No.
Was it your understanding that she was waiting for a plea offer in her own case?
She made mention to me that I asked her about her charges. I wanted to get to know her a little bit. So she told me why she was in. And we discussed that a little bit. And then she said, I'm expecting an offer soon.
That was what she said, expecting an offer soon?
I'm expecting an offer from the state soon.
And that was just over a year ago?
Yes, sir. That was August 30th, 2024.
Just a moment, Your Honor.
I don't know why, as a standard practice, you wouldn't record. Like I said, a lot of hearsay coming from the defense side.
Nothing
Oh,
further
well,
this
she
time?
told me this. She felt this.
So, Mr. Varnes, you said that you interviewed Miss Bird because Donna Adelson's prior defense counsel said that this may be a person who has information.
That's correct.
But that was prior to July 25 when the state listed Patricia Bird as a possible witness for the state, right?
That was August 30th, 2024.
Okay. So in August of 24, the defense, for some reason, would have thought this person may have information and gone to you to interview them.
Correct.
Okay. And defense counsel asked you about this, but you said you did not record your interview with her?
No.
Okay. You could have taken a recorder, like a pocket recorder, into the jail and recorded it, right?
I
If
could
they
have,
asked
but I
you
was
to.
instructed not to record the statement.
Yes, sir. Now, after hearing this statement about how Magbanua basically lied on the Adelsons, killed Dan Markell just to extort them for their money, is that right?
That's not exactly right, but you're in the ballpark, but that's not exactly what she told me.
Okay, can you tell me again exactly what she told you?
Yeah, I'm going to refer back to my report a little bit, if that's okay. I spoke Patricia, and she said that they were sitting at a table talking about the case, and then Bird quoted the following that McDaniel had told her, and that was, after we had him killed, we tried to get the money because we knew her boyfriend and family had a lot of money. We knew that they had money because the family offered the man $1 million apiece to move to South Florida. So at that time, Patricia and Katie, said, why not kill him and get the money ourselves? So then Bird replied with, girl, that's crazy as hell. That's extortion. And Katie replied to her and said, my kid's got to be raised and go to college as well.
So I have a question about that. So
Yes.
according to what you say Bird told you,
Yes.
Bird used the word extortion. That's the word Patricia Bird used.
Yes, ma'am. She
That
said,
Magbanua used.
that's correct.
Okay. Now, when you heard this story, that would be very helpful, right, to Donna Adelson's case. Did you call her prior defense counsel and say, listen to what this lady's telling me? Can I have permission to record this? Can I do a recorded interview with her? This is going to be very important. You didn't do that, did you?
I did call them immediately when I left the jail, and I sent them an email with my summary within an hour.
Okay. Did you ask to go then do a recorded interview with her so you would have evidence of that?
No, I didn't ask.
Okay. And did they ask you to?
They didn't ask me. No, I told them what they told me, and if they have any additional instructions for me, I'll gladly go do what they asked me to do.
All right.
Okay.
Now, if Miss Bird, after all that, do you know why the defense never listed Patricia Bird as a witness?
I don't know the specific reason. I'm not the attorneys on the case. That's
Do you
their
know
job.
why these attorneys never listed Patricia Bird as a witness?
State allow the witness to answer the question before cutting off, please.
Oh, he's getting
Please wait for him to
upset.
finish the answer.
Just repeat, please.
Do you know why either defense counsel never listed Patricia Byrd as a witness?
I have no idea.
You were hired by prior defense counsel, you said?
That's correct.
Okay, and you did charge for your services.
I did charge for my services, yes, ma'am.
That's all, thank you.
Redirect examination.
Just one moment, Your Honor. Mr. Varnes,
Yes, sir.
the state just asked you, according to what you say Byrd said to you, isn't that, in fact, what Ms. Byrd said to you, not just what you claim?
No, that's exactly what she said to me.
Okay. And you've been working
How
in
was
this
that
industry for how
documented?
many years?
I would object to improper bolstering, Judge.
Sustained.
Judge, the state attacked his credibility.
We're not doing speeding objections. I will ask your next question.
Ooh, Judge Everett says, sit your ass down. Plus, asked and answered. You already asked him how long he had been practicing. 27 years. We know it. It's in there. Oh, okay. You paid him.
Would it
and didn't
surprise
use his-
you, sir,
and didn't
to
use
learn
it.
that contrary to what the state implied,
To relevance as to what he would be surprised by.
Overruled. Please let him finish his question first before you reject.
thank you, Your Honor, would it surprise you to learn that prior defense counsel, in fact, listed Patricia Byrd on the witness list that they submitted prior to this case being set for trial September of 2024?
Would that surprise me? No.
Okay. And so contrary to
what?
what Ms. Dugan indicated on cross-examination, it was your understanding that Ms. Byrd was listed as a defense witness.
Yes, sir, that is correct.
Just a moment, Your Honor.
Just a moment. I got to ask Mommy if there are any more questions. Mommy, are there any more questions? No further questions, Your Honor. Watch.
Nothing further, Your Honor?
Will this witness be recalled by the party?
He'll be retained, but he's free to go about.
Told you.
Mr. Varnes, do not discuss your testimony with any other person. You may step down.
Sir, thank you.
Please call your next witness.
Boy, oh boy, what is the defense doing right now? I called it. Oh man. Y'all are saying Ace Ventura, the pet detective in here. What do y'all think about this, man? I'm really trying with the defense, but it's struggling right now. Here we go. Let's keep it moving with this defense for Donna Adelson. Seems like they're going through the motions at this point, knocking these witnesses out. I have not seen one key witness for the defense yet. So hey, let's keep it going. Who do we have up next on the chopping block? Goodness.
Please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth?
I do.
You may take your seat. The attorneys can approach briefly for one moment.
All right, so who is this fine gentleman here? Okay, so they're meeting outside of the presence of the jury, and then we're going to get, this looks like Mr. Tim Kelly on the stand. What Mr.
Could you
Kelly got
please
going?
tell the jury your name and then spell your last name for the court reporter, please?
Yes, Tim Kelly, T-I-O, last name Kelly.
All right, and what is your occupation, sir?
I'm a realtor.
And is that what your occupation was back in 2011?
Yes,
Did you have the pleasure of knowing a young man named Dan Markell?
I did.
At some point in November of 2011, were you contacted by Mr. Markell about seeing some homes?
Yeah, I'm not positive on the date, but if that's the date, yes, he did contact me about some homes.
Would it refresh your memory if you were able to look at the email communications?
Yeah, I can't remember how, yeah, yeah, that's fine.
May I approach, Your Honor?
Yep, great. Yes, 2011.
Is that November 2011?
Yes. Mhm.
All right. And when he contacted you and you were making arrangements to look at homes, were those homes were you looking for a home in particular for his in-laws, Donna and Harvey Adelson?
Correct.
And were arrangements made for you to show homes?
Yes.
And did you in fact show homes?
Yes.
And who was present when you showed the homes? Who was with you?
I believe it was the Adelsons, both of them, the husband and wife, and Dan, and I believe Wendy and the boys, both boys, or just one boy. I can't remember who was there at the time, but I think we had to make arrangements between, cars or so.
Okay. Was it one time that you took them out or more?
I believe it was just one time.
Okay. And did you show them homes in the Tallahassee area?
Yeah.
Okay. And did they end up purchasing any of the homes that you showed them?
No.
Okay. At some point, did you refer them to another realtor that you know named Lisa Carey to look at homes?
I did not refer them to Lisa Carey. No, that was not.
That was not you?
No.
Do you work with Miss Carey?
I did at the time. We were a team.
Okay.
At one point, and I think we were still a team, and we probably were not in 2011.
Okay.
But no.
Okay. Can you hold on just 1 second, please?
Boy, man, defense is having a rough go.
Just briefly, when you came to the courthouse today, did you come and sit inside the courtroom?
I did.
And did you observe and listen to some of the testimony?
I heard the end of the testimony that was being said.
Was it a male or a female?
Female.
Okay. Is there anything about the testimony that you heard that has affected your testimony as to these small issues on looking at a home?
No.
All right. Nothing further.
Cross-examination.
What are we doing?
So you showed these houses to the Donna and Harvey Adelson at Dan Markell's request?
Correct.
And was the thought that they would have more space, be able to stay up here for longer periods of time visiting Dan Markell and his family?
I believe that was it, yes.
Okay. And that was in 2011, you said?
According to the emails, yeah.
So Dan Markell and Wendy Adelson were still together at that
Correct.
time? Okay. And if they got divorced in summer or fall 2012, your interaction would have been about a year before that?
Correct.
And about 2 years before Halloween of 2013, right?
Yes.
Okay. Thank you.
Any redirect from the witness?
No, Judge.
You may step down, Mr. Kelly. Please call your next witness.
Another waste of a witness. It would definitely be an understatement. Definitely be an understatement, J Money. Did Danny's dad walk in with a chain on?
Detective Turner, please raise your right hand, sir. Do you swear or affirm the testimony you're about to give will be the truth?
I do.
You may
Detective
take your
Turner.
seat. Please speak loudly and clearly. You may adjust the microphone if you need to.
And the Honorable Attorney Kel Bell says what we've been saying this entire time and agrees. Are the defense attorneys just calling witnesses to act like they have a case? What is the purpose of these last few witnesses? It's embarrassing, man. Embarrassing. Where is it? Do we have some type of evidence? Is this really anything that we've heard bringing reasonable doubt? No, it's making their case worse.
Good afternoon, sir.
Good afternoon.
Can you please introduce yourself to the jury?
Yes, my name is Josh Turner. I'm a deputy with the Leon County Sheriff's Office.
How long have you been employed with the Leon County Sheriff's Office?
Since September of 2016.
And during your time with the Leon County Sheriff's Office, can you tell the jury a little bit about what assignments you have worked
Yes, I was in 2019 a field training officer, and then in 2020 I transferred into the Criminal Investigations Division at the Sheriff's Office. I worked in property crimes, auto crimes, and violent crimes.
Okay. And in your role as a detective with the Leon County Sheriff's Office, did you come to interview an inmate by the name of Terana Bernhardt?
I did.
And did you meet with her on December 18th of 2024?
I did.
Okay. And subsequent to that, did you notify the state attorney's office that Ms. Bernhardt had information concerning Donna Adelson?
I did.
And did you then attend a recorded interview with Ms. Bernhardt at the state attorney's office?
Yes.
During that interview, did she indicate what, if any, steps, and by she I'm referring to Ms. Bernhardt, took in when she was speaking with Ms. Adelson in the pod at the Leon County Detention Center?
She said that she was speaking to Ms. Adelson throughout the day and sitting in front of a camera at the detention facility.
She specifically stated that she situated herself and Ms. Adelson so that they would be picked up on the surveillance footage?
I'm not sure the exact wording, but yes.
Something to that effect?
Correct.
Okay. Now, previously, did you review State's Exhibit 105?
Yes.
And what was that?
I believe it was the recording of the pod, the annex.
Okay, so there was surveillance video?
Yes.
So after Ms. Bernhardt's interview on December 20th, 2024, at the state attorney's office, did you go back to your office to download the surveillance video?
No, sir. I went to my vehicle and back up to the state attorney's office and downloaded it from there.
Okay, so you went to get your computer?
Yes, sir.
So back then, when you were assigned to the investigations unit, you had access to their surveillance videos?
I did.
Okay, and then you logged in from the state attorney's office and downloaded that?
Correct.
Your Honor, may I approach the witness and show him it was marked for identification purposes as State's Exhibit 105.
You may.
Do you recognize State's Exhibit 105?
I do.
Is this the surveillance, or is this a portion of the surveillance video that you obtained from the Leon County Detention Facility?
It is.
Aside from shortening the video so it was easier to show in court, any changes to it?
Not that I'm aware of.
Just a moment. And at this point in time, I would move into evidence as Defense Exhibit 70, the surveillance video.
Any objection?
My only objection is rule completeness, Judge. I'm not sure how much shortening occurred, but I would ask for all of States 105 to be admitted.
And I can say, Your Honor, that the video that was provided to us as States 105 is exactly what I've copied onto this thumb drive.
The item is admitted. It is to be published in its entirety.
Thank you, Your Honor. Do you guys have the HDMI?
We might actually have some evidence. Let's see.
So that I could use the computer. Is it okay if I stand over here rather than at the lectern?
That's right.
Okay. So, Detective, initially in the video, do we see Miss Bernhardt or Miss Adelson?
Yes, they are back towards the bunks.
And do they walk towards the foreground of the video?
At one point.
I'm going to fast forward a little bit. Who's seated at the table with the dark hair?
That's Drina Bernhardt.
And what does she have in front of her?
A notebook with a daisy and a yellow folder, looks like.
Did the video appear to show Miss Bernhardt putting a chair at the table towards the right?
It does.
Who's walking up now?
Miss Adelson.
Oh, look at Donna in the purple.
Does it appear from the video that Miss Bernhardt got Miss Adelson to sit down at that table?
It does.
And they're engaged in conversation?
Yes.
Hey, over there talking. What is this supposed to show?
Without stating the obvious, there's no audio on this video, correct?
Correct.
Man, look at the sleeping arrangements. That's wild that there's that many people in one area. That's crazy. Yeah, this is crazy. Boy, this is some riveting evidence. I mean, we're just
Detective,
learning
at this
so
point,
much
we're
here.
over 8 minutes into the video. Neither one of them have started writing, have they?
No.
So what, she was set up? No, they're not going to play the whole video.
Can you explain to the jury what Ms. Bernhardt just did?
It appears she took a piece of paper out of her notebook and is showing Miss Adelson something on that page.
Appears that something is already written on that page.
Potentially, I can't tell.
Now Ms. Bernhardt's writing on the piece of paper.
Correct.
And this is supposed to show what? Well, they can't be trying to show nothing was written down now, because now they're writing something down. They were playing tic-tac-toe. Boy.
Appears that Ms. Bernhardt is writing at this point.
Correct.
Judge, given that this is an hour and 14-minute long video, instead of publishing it in full as requested, is it okay if I fast forward to the points that I'm trying to make? Thank you, Your Honor.
I'm sure the jury's gonna watch the whole thing anyway. If you guys were on the jury, would you watch the whole thing even though they're skipping ahead?
1326, who's writing?
Miss Bernhardt.
1417, who's writing?
Miss Bernhardt.
So what, she wrote the letter in Donna's handwriting? Come on.
1433, she's still writing?
Yes.
1446, my client takes the paper and starts writing, correct?
Correct.
Fast forward to 1642. Did Miss Bernhardt take the notebook back?
She did.
Plotting and scheming, yep.
And from this vantage point, we can't see what Miss
I'll watch
Adelson is
it.
writing, can we?
Correct.
Can we zoom in and enhance like they do in those movies?
However, it's clear that Miss Bernhardt's still speaking with my client.
They seem to be engaged in conversation.
$22.50. What do we see Miss Bernhardt doing now?
She placed 2 notebooks on the table.
The one that says you're going places?
And one of them was the hot pink one that we saw. That I think the state submitted into evidence. It's a hot pink.
Correct.
Okay.
It says you're going places. That is hilarious.
$41.24. What do we see now?
Trina's opening the hot pink notebook.
Is she showing Mrs. Adelson something in that notebook?
It appears so.
Fast forward to 44:04. Are they both writing?
Yes.
Writing this all in front of a camera too. It's crazy.
That's about 48:22. Mrs. Adelson handed Drina something. Do they appear to be discussing it now?
It appears so.
We called this detective just so we could watch a video with him. Say, hey detective, does it look like they're talking? Yeah. Hey detective, does it look like they're writing? Yeah. Hey detective. Does it look like they're sitting at the same table? Mm-hmm.
Fast forward a little bit to 51 minutes. It appeared that Miss Adelson had gotten up and is now sitting back down.
That's correct.
Crazy.
Fast forward to 54 minutes.
All right, I don't know about y'all, but we're not doing
It
this.
still appear that they're both looking through the pages and discussing them.
What's your point, counsel? Good Lord. Hey, shout out to Detective Turner for downloading this video from Adamson. What a guy.
Detective, do you recall the date that video was collected? I'm sorry, it's a poorly worded question. Do you recall the date that video was taken?
I believe it was December 19th.
So the day before Miss Adelson met with the state attorney's office. I'm sorry, Miss Bernhardt. Thank you.
Correct.
Just a moment, Your Honor.
Just gotta go talk to mommy. Mommy, do I have any more questions? Or are we just playing the video? Right?
Detective, that's the day after Miss Bernhardt told you that she had information about my client.
Correct.
Nothing further?
Cross-exam. You may.
When you met with her on the 18th, she told you not just that she had information about Donna Adelson, but that Donna Adelson was trying to enlist her, solicit her to give perjured testimony in this trial, right?
Correct.
So you learned that on the 18th. You relay that information to who?
Investigator Newland.
With my office.
Correct.
All right. And the meeting at the state attorney's office ultimately happened on December 20th, right?
Correct.
And at that time, there was a more detailed interview conducted with Ms. Bernhardt to get the information she had about what had happened, right?
Correct.
Okay, and at that meeting, Bernhardt shows up with this pink notebook pictured in State's Exhibit 62, right?
Correct.
And she tells us in that meeting, hey, here's the script that she's written for me that she wants me to deliver at trial, right?
Correct.
And you were able to photograph the thing, and this is what's pictured in State 62?
Correct.
Okay. And
You're
what
going places
were
notebook.
Drena's instructions from the defendant about this exhibit? Why did we have to photograph it instead of impounding the thing?
Her instructions were to read over that and to trace it in her own handwriting and provide that back to Ms. Adelson.
Okay, so she's supposed to copy what's here and give this back to Ms. Adelson.
Correct.
So Ms. Adelson was going to be expecting to get this thing back. We had to send it back with her, right?
Correct.
Mm-hmm.
Okay.
So again, another pointless
Did
witness.
Bernhardt at the meeting on December 20th tell you when this script was authored by Mrs. Adelson?
She was speaking to Investigator Newland. I don't recall.
Based on what she told Investigator Newland, did you go and review that video and find the video that we just watched?
Correct.
All right, and so the video is from December 19th, right?
Correct.
So you didn't look through multiple days of videos. You knew to go to December 19th, right?
Correct.
So Bernhardt obviously said, she wrote this yesterday.
Correct.
I'm supposed to copy it and give it back to her. Yeah?
Yes.
Okay. And so when you went and found the video, did the video appear to corroborate what Bernhardt had told law enforcement that day?
It did.
And when Bernhardt originally reported this to you on the 18th, you said you let investigator Newland know. Did you let Bernhardt know, hey, you're going to be interviewed on the 20th?
No.
Did Bernhardt have any way of knowing that we were going to have a meeting on the 20th?
Not to my knowledge.
In fact, didn't we consider waiting until after Christmas to meet with her? Do you
Correct.
remember that? I was home with a bad injury, bad back.
Yes.
The kids were out of school. It was Christmas time. We talked about doing it after Christmas, right?
Correct.
So wasn't it just dumb luck that we happened to bring her over on the day that she was in possession of this thing in defendant's handwriting?
Yes.
Defense says, well, both women wrote in the notebook. We see one writing, we see the other one writing. Are you a handwriting expert?
No, ma'am.
Would you defer to the expertise of a handwriting expert in determining who wrote this particular thing?
Yes.
I want to publish.
Did we call a handwriting expert on Friday? Yes, you did. Did the handwriting expert say that it was Donna's handwriting and point that out in, let's just be honest, painful detail? Yes.
That video, if you would, at 52:14. Let's go to 41:25. I think we already watched the part where Ms. Bernhardt here does take this pink notebook out and give it to Donna Adelson, right?
Correct.
And it is Bernhardt's notebook, right?
Yes.
And after she gives it to the defendant does proceed to write in the notebook for quite some time, right?
Correct.
And if we go to 58:19, so we see Ms. Adelson get up and walk away, and then she later returns, right?
Yes.
Okay, and if we go to 104.
Mm-hmm.
We see Ms. Bernhardt get up and walk away, and Ms. Adelson continues writing.
Correct.
What is the defense doing, man?
Pretty direct,
Jeez.
Donna, if you-
Detective, we know that Miss Adelson expected this document back that was written in Drina's notebook because that's what Drina said, right?
Correct.
But we can't hear what's being discussed on that video.
Correct.
We have to rely on what Miss Bernhardt says.
Correct.
Now, you testified on cross that Miss Bernhardt did not know that she was being brought up to the state attorney's office for a meeting on the 20th.
I don't believe she knew the date.
Yet, when she came, she brought a bunch of materials with her.
Correct.
And the state attorney's office collected what Drina said they should collect.
Correct.
Look, guys. Hey, yo, shout out to Josh, man. Josh is like, guys, I just downloaded the video and made a phone call. What? Can I go now?
Nothing further.
Will the detective be recalled by the party?
Hell no.
I don't think so, Your Honor. She's released from the state.
Defense will do the same, Your Honor.
Have a good day.
Thank you.
Good Lord have mercy. And that was it. That was... The defense is garbage. I have nothing to say about this. Let me read a couple super chats and then we'll keep it moving. This is insane. Oh, man. Shout out to Amy with the 10 bomb says, it's Wednesday, aka the day we all pretend that a camel is our spirit animal. I know I was. Shout out to Amy showing support. We got lesson here. Donna, give it up. You lost. Dang. Your defense team burned you big time. They have no case.
Right. And so what we have ultimately is that there is no evidence, none.
Shout out to CPE for saying I nailed it with this defense attorney running to mommy. Mommy, do we have any more questions? Like, bro, why are you here? He's just getting up there asking repeating questions. This is embarrassing. And then Amy, of course, with the 2 bomb says, here's my nailed it tax for a different reason. Nailing it in every way. I can't help myself. He said, so what was the point of it? I don't know. Somebody said something. Oh, here we go. This, in my opinion, is hurting the defense, showing how weak their case is. No defense would have been stronger than what I've heard so far. They have nothing, and it shows. I mean, we still have some more witnesses we're going to hear from. But again, a lot of it, as you guys have pointed out, seems like character witnesses that's just saying, oh, Donna's not that bad. Yes, I know she had conversations with Charlie. I know, as a Jewish woman, she said she wanted to dress her children up in Nazi uniforms and have them baptized and, you know, a bunch of other things, but she's really not that bad, guys. Like, this is over, in my opinion. I'm gonna have to see something really, really significant to even feel like Donna has a chance of getting a not guilty. So let's go ahead and get into where are we at. We're going to get into boom. Official day 8. We got a little bit of a delay. Y'all know we like to run on a little bit of a delay, but we're going to go ahead and get started. Again, thank you to all 1,100 of you that have liked the video so far. Likes help out so much, so thank y'all for doing that. Please make sure y'all keep liking the video. All right, let's get into it. We've got the first witness of today. Looks like we're going to hear from Donna's friend or Donna's attorney. Let's see what's going on here.
We are going to continue today with the defense's case in chief.
Is it Donna's attorney or is it Wendy's attorney?
Thank you, Your Honor. The defense will call Kristen Adamson.
Adamson. That is the first time I've heard that name. How do you spell her name? Is it Kristen? Hopefully, maybe they'll have it too. Maybe they'll have it together today. I don't know. I'll be interested to hear. Okay, so actually, this is Wendy Adelson's divorce attorney. Oh my! Now this is going to be something.
Please raise your right hand. Do you swear or affirm the testimony you will give today will be the truth? You may take your seat. You may examine when you're ready.
Thank you, Your Honor. Good morning.
Good morning.
Can you please introduce yourself to the jury?
I'm Kristen Adamson.
And Ms. Adamson, how are you employed?
I'm a lawyer.
She's not going to spell her first name.
I practice family law, and I have done so for 37 years.
Wow.
How long have you been practicing?
37 years.
Okay. Are you board certified?
Yes, I am board certified in marriage and family law by the Florida Supreme Court.
What's involved in becoming board certified?
And I've been board certified since 1996. I had to take a test on family law, and I had to pass a peer review by judges and my colleagues in the Florida Bar Family Law section. I have to recertify.
Are we really doing this right now?
So I've had to also do that every 5 years. I'm coming up, I think 2026, I will be in my thing again where I'll have to recertify.
Have you received any other accolades or awards throughout your career for your work in family law?
I was heavily involved in the Florida Bar Family Law section on the Executive Council for a long time. I am a fellow in the American Academy of Matrimonial Lawyers, past president of the Florida chapter, and I am a fellow in the International Academy of Family Law Lawyers as well. All of those required board certification prior to being allowed to be a fellow, as well as another test nationally and locally, and written tests and oral tests as well.
And
Kristen, respectfully, we don't care. Did you pass the bar or not? Good Lord.
I have been a fellow since 2020, and I was president in 2012.
How long have you been a fellow in the International Academy of Family Lawyers?
Approximately 5 years.
Now, in your work as a family law attorney, did you have occasion to represent Wendy Adelson?
I did represent Wendy Adelson in the end of 2012, I believe it was, 2013, and part of 2014.
Would you call her divorce a bitter custody battle?
I would not. That's not how I would characterize it.
How would you characterize it?
She had a relocation case where she desired to go to Miami. All relocation cases are a little bit more difficult than just regular custody cases because we almost always have to have a court determination on a relocation case because, unlike almost all other family law cases, relocation is a win-lose thing. Almost everything else in family law is sort of a split the baby. Relocation is not. So we did have to go to court on that. And that going to court always is a little bit harder, but in general, this was more or less after that a run-of-the-mill kind of parenting issue kind of case.
Is it unusual to seek...
Until Donna got involved.
Has it been unusual to seek relocation?
No, not at all. I have two right now.
Now, speaking to Tallahassee, why is it not unusual?
Why is it not unusual?
Yes.
It's not unusual because it depends on why someone is here in Tallahassee. Tallahassee has a lot of students with the university. They may graduate with a degree, have children, expect to be able to move somewhere else after they graduate. One person wants to leave, the other person doesn't want to leave. The two cases I have right now, they're not here in front of this court, so they're actually, one of them settled. But one of them, the mother received a potential job offer in North Carolina. The father lived here. She wanted to move to North Carolina. All of his family was here. Her family was not. She wanted to move somewhere else, so that was one. And another one that I have right now is
oh my gosh, we don't care.
Pensacola. My client wants to move to Pensacola because her family is there, and the father does not want to because his job is here. So it's almost always about moving to be close to your family when a marriage dissolves. I mean, that even happened with my sister when she divorced in Florida. She moved to Atlanta to be close to my parents. It's a very common thing for people to want to move to be near their parents, no matter how old they are.
Now, do you have parents who attend client meetings?
I do. And it doesn't seem to matter whether my clients are 20 or 40. I have many cases where a mom or a dad or sister or somebody comes to almost every meeting I have, including mediations, and they're heavily involved in the divorce of their sibling or their child, regardless of age. It's just something, families tend to be enmeshed in their other families' divorces. They do. I usually let them come to mediation because sometimes it's important to hear how the mediation is going so that they don't try to armchair quarterback it after the mediation.
Understood.
They let family come to mediation? I've never heard of that. Is she talking about extended family?
Now, you indicated
immediate
that you
family?
typically
Any
have to
family?
go to
That's
court
weird.
For relocation. How difficult is it to get court approval for relocation?
Well, I always tell my clients in Leon County that even though, according to the statute, there's no presumption that someone should be able to leave or not leave, I do think that there's a presumption against relocation. And I always tell my clients that it's a very hard thing to obtain a relocation. That you have to have kind of special circumstances, and there's a whole laundry list of statutory criteria that you have to meet to try to be able to relocate. And so we sit down and we go through the statutory criteria and determine whether or not you'll be able to do it. Most of the time, I tell them it's a 50-50 shot at best. Sometimes a little bit more, sometimes less.
Okay. Did you have that conversation with Wendy Adelson while you were representing her?
I did.
Okay. And did you advise her of that same information?
I did. Basically, I told her that if this is something that was important to her, this was her one shot at it. If you get divorced and then try to relocate afterwards, you're probably not going to win unless something really substantial comes up and changes it. So if she wanted to try to be able to relocate, this was her shot at it at best.
So in other words, is it, not that it's easy, but is it easier to try to obtain relocation in the initial proceeding or in a modification?
In an initial proceeding.
Okay. Now, the standard for a modification, what is that?
Standard for a modification is a substantial change in circumstance. And at the time that I had Wendy's case, there was also another component which no longer exists. But at the time that I had Wendy's case, you had to prove there was a substantial change in circumstances, that it was in the best interest of the child for a modification, and that it was detrimental to the child not to modify. The detriment part does no longer exist. Now you have to just prove there's been a substantial change in circumstance and that it's in the best interest of the children. But at that point, you would have had to prove that it was detrimental in some way to the children to modify.
Is that why you advised Miss Wendy Adelson, if she wanted to try relocation, she should do it at the front end?
Yes. Proving detriment is hard to describe to clients because they don't understand how substantial that really has to be. It has to be very substantial. Children are failing in school, children are potentially being neglected or abused, or there's alcohol or drug or mental illness.
Okay. Have you ever been successful in convincing a judge to grant relocation?
I personally have only won one case in 37 years for relocation.
So, would you say it's difficult?
I think it's difficult.
Oh my goodness.
Now, even though you've only gotten court approval for one with the client, have you been able to successfully negotiate for relocation in other cases?
She's been practicing 37 years and has only won one relocation case. Hey, y'all better not. She's the best of the best. Amy just said it in the chat. She says she's AV rated, best lawyers, lawyer of the year, super lawyer. She is one of the best in the Southeast, allegedly. And she has won one relocation case in 37 years. Hey, y'all trying to get relocation? It ain't happening. Hey, yo. Sorry to hate to tell you. This is one of the best telling you ain't relocating. I'm sorry.
Even though you've only gotten court approval for one with the client, have you been able to successfully negotiate for relocation in other cases?
I have been able to negotiate relocation in other cases, sometimes through help of mental health professionals who will interview the parties and the children and make recommendations. Sometimes we'll have a guardian ad litem appointed to make a recommendation. We'll have a parenting evaluation or something like that that makes a recommendation. And if you have those things behind you, then it does help, because most people don't want to go to a judge if you have a mental health professional that says, oh yeah, relocation would be great. So we have been able to do it in that way. I also have been able to have relocations when you have an older child who really wants to relocate and the other parent doesn't object. Or sometimes you have, like in my sister's case, which I actually shouldn't have, but I did represent my sister. She moved to Atlanta, and then her husband was able to obtain a job in Atlanta and move up there to her former husband.
She talks too much.
We negotiated all those things.
And I think you said you explained all of this to Wendy.
I did.
Was she aware that the chances of success were low?
Yes, I mean, I told her that this was her shot I gave her, I thought she had some
It
good
didn't matter
reasons.
to
I would
Donna.
never have someone file a relocation if I didn't think they had a shot at it. So I think she did have a shot at it, for many reasons. But including the fact that her parents were down there, that Professor Markel had a very flexible job. He had family in South Florida. These were very little children at the time. We did not have the presumption of 50-50 parenting, and she had done most of the parenting. There were lots of reasons I felt like she had a really pretty good shot at it. But I did tell her it's not going to be easy.
Okay. Now, let's talk about the family law rules of procedure generally. Do the rules require the exchange of certain materials in dissolution proceedings?
Yes.
And what are those?
We have mandatory disclosure in divorce and modification proceedings, including custody and just regular divorce. And pursuant to the Florida Supreme Court rules and 12.540, we have to file a financial affidavit under oath that the parties and lawyers and their paralegals help them fill out. We also provide a laundry list of documents that keeps getting larger. It's bank statements for 3 years, it's retirement statements, it's deeds, it is credit reports. I mean, it's a very large, voluminous amount of documentation that we have to exchange with the other party, the other counsel.
And when completing the financial affidavits, specifically when you completed Miss Adelson's family law financial affidavit, did you gather records in the process of completing that so you could disclose everything appropriately?
We did. We gathered all those records and we exchanged them and gave them to opposing counsel. Sometimes what does happen is the other side has all the records. For example, tax returns, we have to exchange tax returns for 3 years. Sometimes the father or the husband might have all the tax returns, the wife might have all the tax returns, so you do rely sometimes for the other side to provide the documents that you should have. But
Now,
that does happen.
Do you have to list all assets on the financial affidavit?
Within reason, you do have to list your substantial assets. Sometimes I have people that want to list minutia assets, de minimis assets. We don't really do that. We try to keep it as global as possible. We don't list everybody's clothing or, but we list all the cars, generally speaking. But financial affidavits are also a work in progress. We can amend them. And that is part of what happens when you go through a dissolution. Sometimes more documents come to light. A lot of times when people are getting divorced, they're not always in their best mind, and they're not always working as well as you'd want them to, so it takes a lot of help to get a lot of these documents sometimes. So we amend financial affidavits, and I always tell them, don't worry, we'll amend before we go to court. If we have more documents that come up or we find out more information, or you change jobs, we have to do that.
What about non-marital assets?
We generally list non-marital assets as separate if we have knowledge of them. Non-marital assets can be very clean, where you absolutely know something's non-marital, or they may not be, because what people don't always understand, it's an education process as you're educating your client as they're going through divorce. Simply because it's in your name alone does not mean it's non-marital. So it can be in your name alone and still be marital if you have obtained it during the marriage. However, sometimes it can be both, and we have to separate things out. I know with Wendy's case, that was one of the things that happened, is she had an asset that was potentially marital and non-marital because she owned some of it before the marriage, and then she had some of it, she contributed some of it after the marriage. So it's hard to determine how much initially, and we sometimes have to hire expert witnesses, financial witnesses, to come and help us determine what part of this is non-marital and what part is marital. For example, if you have a retirement account and you've contributed to that retirement account before the marriage, everything you contributed before the marriage is yours. It's not marital. And whatever increase in value due to the market is also non-marital. So if you have
Is Florida law different? With all due respect to this top of the top lawyer, I've studied and understand family law very well. And what she's saying does not sound correct. It does not sound right. Unless Wendy had a prenup in place and that's what she's saying. But this does not sound, yeah, Florida law, divorce law must be super weird. Because I know here in Georgia, that's not the way it goes.
$100,000 in a retirement account, you get married, that $100,000 theoretically, except for 2009.
But hey,
that
37 years, I'm not gonna
continues
doubt
to
it.
grow, so you're entitled to the growth on it too, as non-marital. So that's why sometimes it gets very complicated and we can't determine it initially when doing a financial affidavit, but we do try to determine it by the time we get to court, at least.
Florida.
Now, I want to back up a
is
little
wild.
bit. What happened with Wendy Adelson's relocation?
She did not win her relocation.
Can you tell us what happened at that hearing?
So we had a hearing on the relocation. We put on Wendy Adelson, and she testified about the reasons that she wanted to move. She did have a job offer in Miami. We put on the lawyer from the law firm that had offered her the job. He testified about what the job would be, how much more money she would be making, and the flexible hours, et cetera, et cetera. We put on all of that, and then at the end of our testimony, the judge asked to speak to counsel, which happens a lot, and she took counsel out. It was me and Professor Markel's lawyer, and she told us she understood why Ms. Adelson wanted to move, but she wasn't going to allow it because she didn't think she had met her burden of proving it was in the best interest of the children.
Seems pretty
that
straightforward to
hearing,
me.
Or after the judge made those comments, did Wendy go out in the hallway to speak to her parents?
Well, after she made those comments, I went to both Mr. Duggar and I went to our respective clients. We told our respective clients what the judge had said. And basically, if the judge had already determined this without hearing from Professor Markel, we didn't really have a chance of winning this at all because she'd already heard the best case of our case. So I talked to Wendy about that, and then Wendy's parents were there, and I actually spoke to Wendy and her parents, and then she went and spoke to her parents again, I think, if I can remember. It was a long time ago, but I think she spoke to her parents outside of my presence as well.
Did Wendy ultimately stipulate to the withdrawal or the denial of that petition with prejudice?
So what happened at that point was we went back into court. The judge denied Professor Markel's motion to dismiss because he had filed a motion to dismiss our pleading. She found our pleading to be sufficient, so she entered an order denying his motion to dismiss. She entered an order that we stipulated on the records that we would agree to the denial of the relocation. And then she entered another order where we all stood there and worked through with the judge what the temporary visitation would be for the next summer and the next several months before we got to another agreement.
And at this point in time, I believe it was approximately the third week of June of 2013?
Yes.
Okay. And what was Wendy's reaction?
At that point in time, I think she was upset that she wasn't going to. I mean, nobody wants to not win their case. She was upset. She was always calm during all of my meetings with her. She understood. She's a lawyer. She understood what I was telling her in terms of the legal ramifications. I think she was resigned to it. We did speak a few times after that because we had to get geared up for the next round of this. We had already gone to a mediation before that, and we had not been able to agree at the mediation on the relocation. So we knew we had to go to another mediation. So I talked to her several times about the next mediation, which would be dealing with all the other parenting issues and the financial issues. So I did talk to her quite a bit after that, and she seemed resigned to it.
Now, although the court denied the petition, would it have been possible for Wendy Adelson to offer Mr. Markel any financial incentive in order to convince him to change his mind?
Well, we hadn't finished the case. We still were going to go to another mediation. It's always possible. I tell everyone that even after an unsuccessful mediation, people settle their cases on the eve of trial all the time in some way or another. They do. And it's always best if you can settle your case and not leave it to a court. You have much more control if you are the decision makers rather than the court.
Is there anything improper or illegal with one party offering a financial incentive to the other party to obtain relocation?
No, and I actually have negotiated that in the past,
Now,
and since that time as well.
Subsequent to that hearing, did you have another mediation on the dissolution, the distribution of assets, and the parenting time?
We did, and at that mediation, we came very close to settling it, and we were there for quite a long period of time. but we did not settle it at the mediation. I think we settled it within a week after the mediation, where opposing counsel and I exchanged a lot of phone calls, and because we had gotten very, very close at mediation, and we were able to resolve all of it within a week of mediation.
Now,
And before, we had a court hearing trial set, I believe, and so we were able to do it before the court trial.
Thank you. Prior to adjourning mediation, did an issue come up concerning a potentially non-marital asset that Ms. Adelson had?
It did.
And what asset was that?
It was the, if I remember correctly, it was the Charles Schwab account that we had listed on the financial affidavit in the marital portion, and then on the non-marital portion, we had listed Charles Schwab non-marital portion to be determined. And we went into mediation in that way, not knowing exactly what was marital and what was not marital.
Now, I know in our pretrial discussions, you indicated, can you typically talk about what happens at mediation?
Mediation is confidential, and that's one of the things I tell my clients is that the mediator can't be called to testify about what happened in mediation, and I can't testify about what happened in mediation, et cetera, et cetera. So the theory behind that is that people will be as open to negotiation without fear that it's going to come back in court and hurt them in some way in front of a judge. You can't talk about the settlement offers that were made. For example, in mediation, if they say, oh, but he offered to pay child support above and beyond child support, and then we don't reach an agreement, you can't come into court and say, but he made this offer. So it keeps everybody moving forward and not worrying about what the offer is.
It's up to the judge at that point. You don't figure it out in mediation, oh well.
If you're ordered to do so by the court.
There is, and there's also an exception about what happens in mediation if the marital settlement agreement is asked to be set aside for some purpose like fraud or overreaching or something like that, then the terms of it and the mediation would potentially be able to pierce that veil of confidentiality.
But for our purposes, in order to talk about what specifically happened concerning that asset in mediation, do you need the court to order that you disclose that information?
I would certainly like the court to order that. I don't want to fall foul of any mediation rules. I can tell you that my client has waived that confidentiality. The mediator, who was a friend and a lovely person, Joe Boyd, he is not with us anymore, and Professor Markell is not with us anymore. So
Rest
a lot
in
of
peace.
people in that mediation are gone, and Ms. Adelson has waived confidentiality.
You beat me to the punch, Ms. Edison. With the waiver of confidentiality by your client, I will order you to testify on the subject matters being inquired into. The state may cross-examine as to all subjects as well. You may continue.
All right,
Thanks very much,
confidentiality was waived.
Ms. Adamson, can
Here
you
we
tell
go.
us that Charles Schwab account that you mentioned, how was that addressed at mediation?
So this became sort of a last-minute little dust-up during the mediation. So what we did was we called the Charles Schwab account representative. And this is not uncommon in mediation, and I had Joe Boyd, who was the mediator, come in and talk to the Charles Schwab account representative. So it wasn't just me talking to the representative and telling the other side what had happened. I wanted the mediator to actually do it and to hear it. And so he talked to the Charles Schwab representative, who outlined, in his opinion, what the possessory status of that Charles Schwab account was, who owned it when, where it was, how it had been separated into multiple accounts apparently, and which ones were marital and non-marital. And then he went into the other room. We're not in the same room. We're in, Ms. Adelson and I are in one room, and Professor Markell and his lawyer are in another room, and the mediator is going back and forth between the two rooms. So in our room, he listened to the what the Charles Schwab representative said, and then he went into the other room and told them what he had said. And after that mediation, Mr. Duggar and I discussed the fact that it actually happened, and everybody felt comfortable with what was marital and non-marital. And that was when, along with other little things about the parenting and other loose ends being tied up, we were able to actually have a marital settlement agreement. The Charles Schwab account, in all its different permutations, was listed in the marital settlement agreement, and Professor Markell had almost $500,000 worth of non-marital Charles Schwab accounts of his own.
Okay.
So he had non-marital money as well.
Florida is such a weird place, man.
Discussed, Mr. Markell was aware of the non-marital status of that portion of Wendy Adelson's portion of what she would get?
He was.
And as you said, shortly thereafter, that case settled.
Within a week, I think, ish.
Nice.
Shortly after the divorce was final, did Wendy invite you to a get her groove back party?
I don't remember when the party was, whether it was a month or 2 or 3, but she did invite me to a party in her new, I think it was an apartment or townhouse, I don't remember what it was exactly, but she invited me to a party. It was called Wendy Gets Her Groove Back, and I had several friends I knew of Wendy's that were there as well, and it was just sort of a, Wendy's in a good place, come celebrate my new life party, yeah, in Tallahassee.
Throughout the course of your representation,
This is so weird.
Could you tell us the total amount of attorney's fees and costs that you incurred in this case?
I think the total amount of costs and attorney's fees, we did take a couple depositions. We had 2 mediations. One was ordered by the court on that relocation case, and then that was a pretty short mediation. It was only a couple hours. The other one was much longer. I think the total attorney's fees were probably about $30,000.
And costs of?
It's not bad.
That includes costs and everything, I think.
Okay. Now,
I know that sounds like a lot, but it wasn't that much compared to a lot of litigated cases.
okay.
Yeah, it's not bad at
Now,
all.
litigated cases have multiple evidentiary hearings.
Correct.
Did this?
No, we had. I don't believe we actually had any evidentiary hearings. The only other hearing that we really did have was post-dissolution.
So aside from the relocation, prior to the divorce being final, there were no contested hearings.
There were no contested hearings.
Now, did the marital settlement agreement require that Mr. Markell pay Wendy and yourself certain sums?
So according to the marital settlement agreement, Professor Markell kept the house. So he was supposed to pay Wendy for her part of the house. And all the other assets were divided equally, so that he kept an equal amount, she kept an equal amount. He was supposed to pay, I think it was about $120,000 for his part of the house within 60 days. He had the money, because he had more than $500,000 in non-marital assets, and he had also marital assets as well. He was supposed to pay me $10,000 in attorney's fees because he made a lot more money than Wendy did, and it's based upon, attorney's fees is based upon who has more resources, and he had considerably more resources than Wendy did. So that was part of the agreement. He was supposed to pay me $10,000, he was supposed to pay her $120,000, all within 60 days of the agreement, which was July, sometime 2013.
July 31st?
I think that's right.
Did Mr. Markell pay the sums that he was obligated to pay under the settlement agreement?
He was supposed to transfer, if I remember, from one of his Charles Schwab accounts to Wendy, the money. He gave her $50,000 of the $120 in a pretty timely basis, and then he just didn't pay the rest. And I don't like to file enforcement hearings on things like that because it takes a long time to get to court. It's not fun. It's just kind of, so I was pretty much once a week or once every other week asking opposing counsel if Professor Markell was going to pay.
Did he pay?
He did not.
What did Wendy ask you to do to enforce that?
At some point, I wrote a letter, I believe, to opposing counsel. So this was, first it's a bunch of emails and phone calls, and then it's a letter saying, please pay, so we don't have to file an enforcement. A part of our marital settlement agreement, if we have to file an enforcement and we win, which we would have because he had to pay, then he would also have to pay additional attorney's fees for doing that. So then it just becomes more and more money that he owes and he's not paying theoretically. So, and this was all on property issues. So unlike custody, we're not going to be able to, or child support, we can't put him in court. We're in jail. We're not going to be able to put him in jail or anything like that. We're only going to have to be able to go after his assets and things of that nature. It's a lot easier if people will just pay. So I finally filed a motion for enforcement saying he'd only paid $50,000. He owed the other money, and
he only
owed me
paid
money, and I asked for a court hearing on all of that.
Sounds like it was a pretty straightforward motion that you filed.
It was pretty straightforward. It was probably 4 or 5 paragraphs.
Okay. Did that prompt Mr. Markell to pay?
No, it did not.
What happened?
So then Mr. Markell hired a new lawyer. And his new lawyer
Delay.
filed a responsive pleading to my motion, basically saying that he shouldn't have to pay because Ms. Adelson had breached the marital settlement agreement.
How did he allege that she breached the settlement agreement?
He filed multiple motions, but his first responses and motions, his first one, basically, if I remember correctly, was all about the money. And he said that he shouldn't have to pay because she had hidden the Charles Schwab money from him, and he used to have power of attorney, so he knew that she hid the money, which doesn't make sense, because if he had power of attorney, he would know what the money was, so it didn't make sense to me. But anyway, that she had hidden that money, and that she hadn't told him about several other of her retirement accounts, and therefore the marital settlement agreement was breached, and he shouldn't have to pay her the money.
So he filed a response, but did he seek to have the settlement agreement itself voided or set aside?
He did not. So, and that is what I told Wendy at the time, is that is not a proper defense for not paying the money. Professor Markel, it was pretty obvious that he had actually written this pleading himself, and the lawyer just signed off on it. It had footnotes, which is not something litigation lawyers would do. It was voluminous, and it was very personal about what was going on, and Wendy and how I don't think at this point he might have alleged that she had committed fraud, but an appropriate pleading would have been for him to file a 12.540. I know it's kind of technical, but basically if you think that an agreement is reached and it is not in good faith, or there's assets that were not provided, then you must file within a year for a 12.540 to have the whole agreement set aside. You can't just say one good breach is another. And I filed a pleading basically saying that his motion should be dismissed because it was inappropriate. And
you filed a motion to strike as a sham pleading?
I did. I filed a motion saying this was an inappropriate pleading and it should be dismissed because it wasn't the correct way to go about doing what he wanted to do. And so I then tried to set hearings on those motions so that we could move this forward and everybody could get paid.
Now, in the process of doing this with his responses, did he file subsequently a pleading that further alleged fraud on Wendy's part?
I think he filed at least one or two more pleadings that did that.
And before we get to the final one, that, you advised Ms. Adelson along the way of what you just told us about the unlikelihood of his success.
I did not think he was going to be successful in his response because it was an inappropriate pleading and it should have been dismissed, which I believe it would have been dismissed. And you can't say, I'm not going to pay you because you breached this agreement by not giving me documents. That just, first of all, there's a lot of case law that says that if a case is heavily involved with mediations and lawyers and all these documents have been produced, you had your shot at it. So he was not going to be able to do that. Plus, I knew that he knew about these assets because we had that conversation at mediation, and I had several conversations with his lawyer afterwards, and the marital settlement agreement listed all these assets that he was claiming he had no knowledge of, and they were already listed on the marital settlement agreement. So it was not, in my opinion, a successful response, and I told Wendy that it wasn't, and not to worry about it.
Now, there was a hearing in February of 2014. I think the records indicate that that Mr. Markel and his attorney were attempting to depose Ms. Adelson.
So what happened was I wanted to take his deposition so I could find out why he wasn't paying. And their response was to want to take her deposition, which I did not believe was appropriate because we were simply trying to enforce a marital settlement agreement. And
I don't know what this has to do with Donna.
That would happen in terms of that marital settlement agreement that would require him to ask her any questions. So I did file a motion to protective order so that he would not take her deposition. We went to court on
What was she
that issue
protecting her from?
in front of the same judge.
And what happened at that hearing?
At that hearing, which we did not have transcribed, which we usually do, but we didn't because it was pretty much a 15-minute hearing, the judge read all of the pleadings and she said that she was very unhappy with Professor Markel's pleadings. She did not like them. She thought they were a poke in my client's eye, and they were not appropriate, and she never wanted to see pleadings like this in front of her again, but she was going to allow the deposition.
With some limits?
With limits, yes.
Okay.
I don't remember exactly all the limits, but they could only be about certain things.
Now, subsequent to that, did Mr.
And Wendy
Markell
still lost a
file,
relocation.
an additional pleading concerning complaints that he had about right of first refusal, parenting time, and things of that nature?
So that's the first time, and this is actually almost a year after the divorce, and we're done with the whole divorce. That's the first time that he brought up any parenting issues. And it was a series of issues that he had now about the parenting, and it was that Wendy wasn't allowing him to FaceTime with his children as much as he wanted to. That they weren't allowed to go to be present at the same birthday parties. That if there was a birthday party that he was at, she wouldn't come. I mean, things like that, and that she wasn't. I think there was a right of first refusal in it, and that she was letting her mom watch the kids, and he didn't like her mom watching the kids, and I think he alleged that her mom was saying bad things to the kids, potentially about him. I think that was the first time. He also, I think it was that pleading where he went on a little bit more about Wendy and how she should probably be disbarred from the practice of law.
Dang.
And that I should be disbarred from the practice of law.
Oh.
I think it was that one.
As he's filing these things, are you...
Oh, okay. Well, I guess he deserved to die then. What are we doing here? And I don't know. We haven't heard Donna's name once during this testimony. What do y'all think is happening? I'm trying to go with the defense here, but what this has to do with Donna, I have no idea. I mean, it's clear that Wendy and Danny had not so great of a divorce, that they had an up and down roller coaster type of relationship going throughout this divorce. But I have yet to hear what any of this testimony from Kristen Adamson has to do with Donna. Hopefully she'll tell us. I don't know what's happening.
I think it was that one.
As he's filing these things, are you still trying to set a hearing, or set the depositions and set hearing on your enforcement motion?
I've still been trying to do that. There were a number of hearings that got canceled. Some of them I think were because of the court needed to move things. Some of them were because I was trying to work this out. Still, I'm always trying to work out a case and not go to court if I can. So we were trying to work it out, but he wasn't paying, and I was trying to set hearings on all of this so we could get the money and we could get his motions dismissed because they were frivolous.
Okay. Now, the one motion concerning my client, Mrs. Adelson, he referenced parental alienation. Have you dealt with parental alienation in your practice before?
I have.
And what is that?
Well, it's not actually a recognized legal term, and it's not actually a recognized mental health term by the mental health professionals, but it does happen. I mean, we all know that there are parents who do alienate their children against their spouse by saying really terrible things or trying to put up roadblocks to parentings. And I've had cases that were pretty serious in the past where little children, it doesn't usually impact teenagers. By the time they're teenagers, they've already done they want to do their teenage thing. It really truly impacts not children this young either. It's usually like 7 to 9-year-olds that we deal with when we have parental alienation, where they become completely aligned with one parent inappropriately. And not because the other parent is doing something like abusing them or something like that. It's because the other parent truly is putting up these roadblocks. They do use those
Happens
terms.
all the time.
The statements that were included in the March 26, 2014 pleading filed by Mr. Markell that were attributed to my client, would that have resulted in any sort of relief preventing my client from having any sort of unsupervised time with the grandchildren?
No. It's not possible. And I told Wendy that.
Okay. Now, as Professor Markell continued filing things, did you realize that you were going to have to become a witness?
So I can't remember how many pleadings he filed on that regard. It may have been 3. And it was the last one that he filed. I believe it was in May, I believe, where he said that where he became very personal to me which occasionally happens. It doesn't usually happen with professional people, so I was surprised. But he became very personal towards me and said that I had committed fraud and that I should be disbarred based upon what had happened. At that point in time, I knew that I was going to actually have to be a witness now in this case. And as a witness, you can't be a witness
this
and
got
a lawyer
messy.
representing your client. So I knew that I had to withdraw. So I withdrew so that I could testify in the case that was going to come up. And I sought a new counsel for Ms. Adelson at that point.
Did that result in the hearing that had, now, let me back up. Had you been able, prior to withdrawing, to schedule the hearing on your enforcement motion as well as Mr. Markel's motions?
I had it scheduled. It was scheduled, but then I had to withdraw because he filed that pleading after it was scheduled. So I had to withdraw, and I called Jimmy Jenkins and asked him if he could please represent Ms. Adelson. He said yes, but he needed more time to get up to speed on that case, so the hearing had to be moved.
Okay. And around this time, were you aware that Mr. Markel had to change counsel again as well?
I did not know that.
Were you aware that as Mr. Markel is filing these pleadings, including the one in March, that he continued to ask my client to watch the children during his time sharing?
I don't know what they were. I don't know anything about their correspondence. I've really only dealt with Wendy.
And on that note, we discussed earlier that it's not unusual for parents or family to be involved in meetings. Was my client, Donna Adelson, involved in any of the meetings that you had with Wendy Adelson during her initial dissolution proceeding or any of the enforcement proceedings after the fact?
She was not involved in any. I never spoke to her except for the one hearing on relocation that she and her husband came to. But even then, it was very brief. They were very nice, lovely people. I didn't, even after even afterwards, they were fine. I had no issues with them, but I never spoke to them. I never emailed with them. They never came to any meetings. They were not involved with me.
Okay. And do you have a recollection of whether my client and her husband were in the courtroom for the relocation hearing, or were they out in the hallway?
I believe they were in the hallway. I don't believe they came in.
Okay, just a moment, Your Honor.
Anybody see some reasonable doubt for Donna here?
Cross-examination.
Guys, you know, when we review these cases, we look at it from the standpoint of the jury. As a juror, how are you factoring this testimony in? How? Let me know. My God.
Morning.
Good morning.
So you said you weren't aware of Donna Adelson's involvement.
She was not involved with me.
Okay.
So no.
Did you know that she was drafting Wendy's filings and having Wendy copy and paste them to send to you?
She couldn't have drafted any of the filings because I drafted the filings.
What she would like to be put in the filings, how about that?
I'm not aware of any of that, no.
Okay. Do you know that she was drafting things for Wendy to put in her filings in Wendy's voice?
Not that I'm aware of.
Okay. Did Wendy, though, give you input on things maybe to put in filings or things that she would like said on her behalf?
Not a lot. I talked to Wendy on a pretty regular basis when I was filing something on the phone or by email. And she was a very good client, in all honesty, where she listened to me and she basically, we have clients that don't. Now we have clients that give you ChatGPT and want you to do ChatGPT pleadings, you know, so there's that. She wasn't that client. She would say something like, well, and my pleadings were very short. I mean, my pleadings were very, very short. They were to the point and like, no, dismiss this, that's not true. There wasn't a lot more going on in most of them.
So you wouldn't have knowledge of Wendy sending pleadings to her mom and saying, let's edit this?
No, because I wouldn't have edited it based on that anyway.
Okay.
I mean, maybe they did, but I didn't do it.
All right.
And I never heard about it.
Okay. So this would have been between Donna and Wendy.
If that happened, yeah.
You mentioned that, of course, she had a shot with relocation, but given the situation in this case being that the kids were raised in Tallahassee, the parents' jobs with FSU,
you were not personally surprised when the relocation was denied.
I'm never surprised when a relocation is denied.
Because it's hard to prove detriment at that time.
I'm always hopeful, you know, but,
Right.
And I thought she had a good shot, or I wouldn't have let her do it. I mean, I'm not going to file a frivolous motion, and I thought she had a good shot for a number of reasons.
Regardless, though,
Sure
of
you
what you
did.
think, do you ever have clients or family members of clients who have unrealistic expectations of what the courts will allow or what you can do for them?
Yes.
Okay. Even given your best guidance?
Yes.
Okay. That's not an uncommon thing.
No, that's why parents are often involved in these cases and come to talk to me about what they think I should be doing. Yes, I get that a lot.
Right. And at that relocation hearing, were Donna and Harvey Adelson possible witnesses?
You know, I've been trying to think about that. I think that that's probably why I had them sit outside, is because they
Right.
could potentially be witnesses in invoking the rule. However, I think we had come to either the close of our case.
But you wouldn't know that until
Right.
you were done calling witnesses.
Correct. So that's right. Yeah.
Okay. So that's why they were in the hallway.
That's why
most
they were in the
likely.
hallway, yeah.
Okay. Not because they didn't care or they weren't involved.
Oh no, they were very nice. I mean, I met them. They were there when I got there in the morning. They introduced themselves. They were very nice. We did our thing. I came back and told them afterwards. Nobody yelled or screamed or cried or did any carrying on, which sometimes happens. So no, it was all very appropriate.
Okay. Do you sometimes have clients or family members of clients who take the news harder than you do when they lose something in court?
Well, I don't like to lose either. So there's that. I don't like it. That's why I don't like to go to court if I think I'm going to lose. That's why I want to settle things. But sometimes they take it really hard, especially family if they're not there. They do.
Okay. And you said Wendy was upset when she was denied the relocation, but she was calm. Oh, let me also ask you this. Wendy Adelson stipulated to the denial of the relocation after you found out behind the scenes from the judge that it was going to be denied.
Correct.
Okay. And she was upset about it, but calm.
Yes.
She's not screaming.
No.
No. Okay.
And I have people do that. I mean, I've had to have my own clients taken by the bailiff out.
I'm sure you've seen it all. And how did Donna Adelson feel about not winning the relocation?
I don't know how she felt. I can only tell you that I came out, I talked to Wendy, and then briefly.
Oh,
as
now
far as
she
I
can't say how she
remember,
felt.
because, I mean,
I'm
it was
sorry,
accused,
Ducky.
I think I talked to all of them and kind of told them what happened and what was going on. And, you know, I didn't agree with the judge, but this is the judge, and they get to make the decisions. And I think that Wendy went and talked to her parents without me, and then came back and said, okay, we're good. We can go into court and we can stipulate.
Okay.
Which is what I had suggested.
So if there are emails of Donna Adelson being upset about and very disappointed and about it being denied or unhappy with your representation for some reason, that's not something she's telling you to your face?
No.
Okay. You talked about Dan Markell not paying what he was supposed to pay according to the settlement agreement. In Dan Markell's court filings, did he give, and I know you don't agree with those reasons, but did he give his reasons for not paying?
He gave his reasons,
Okay.
yes.
And that included the fact of that he was accusing Wendy of noncompliance.
That's true.
Okay. Eventually, did you seek to have Dan Markell held in contempt of court?
I did. It was part of my motion, was to have him held in contempt of court and enforce it. That's not the kind of contempt where I can throw him in jail.
Yeah, what does that mean, contempt of court? Can you explain that?
So in a child support hearing or an alimony support hearing, if someone doesn't pay their child support or their alimony, we can have someone held in contempt of court and put in jail if we can prove they had the ability to pay, but they're just not paying, and then the court can put them in jail until they pay the amount they're supposed to pay. Okay.
Ability to pay is
It's a
is
property
huge.
issue. We can't really have them held in contempt of court because it's a property issue, and that was part of why Dan's pleadings didn't make a lot of sense, because he was mixing up property and child issues, and you can't do that. It's strictly property or it's kid issues. In a property issue, it would be a multi-step thing to have him held in contempt of court. He would basically, the judge would have to find that he was not paying, he's willfully not paying, and then...
Could I ask you a different question?
Okay.
I'm sorry.
But even in a property situation, the court could put him in jail ultimately, but it would be multiple steps I would have to go
talking
through.
her to
It wouldn't
death.
be just one step. and it would be difficult.
What ultimately is the consequence of that is my question.
So ultimately, the ultimate consequence is we would probably get a final judgment against him for the amount that was owed.
Like a lien.
And a lien against, and we would get a lien against the house, and we would, and then I have to do this often, I would send them to a debt collector attorney who would then have to file another suit to be able to collect that money, and then they would probably be able to go into his assets and get the assets. So it's a multiple stage process, which is why I just wanted him to pay the money and not make me do this.
So if it was successful, probably a lien, worst case scenario, he could go to jail. And then him being an attorney, though, could he lose his bar license, possibly? If he's held in contempt of court? Or at least be in trouble with the bar?
He could. I've had lawyers held in contempt of court over these issues before. I haven't had one lose their license yet.
Okay.
But they could. It is a possibility.
Did you inform Wendy Adelson that you were seeking to have him held in contempt?
Yeah, I'm pretty sure I probably did. Because it's kind of a generalized form. It's a motion for contempt and enforcement.
Okay. And then at some point, did he allege that Wendy Adelson should be held in contempt?
I don't know if contempt, I can't remember if he actually said she should be held in contempt legally the way that I was using it. I think his pleadings were much more, Wendy should be disbarred.
Okay.
I mean, that's what he specifically said.
Right.
She was committing fraud and she should be disbarred.
Would you describe this
Wow.
divorce as contentious?
I wouldn't describe the divorce as particularly contentious.
Well, divorce is
at all
contentious.
compared to most of the divorces I had, and we settled it. I don't settle a lot of my cases.
On its
so we
own.
actually go to week-long trials over things of that nature. I think it was like any divorce where there were ups and downs of moments where it was contentious and not fun. But for the most part, we kind of settled it. We settled it after mediation, and it wasn't a problem. I do think that this whole issue of the enforcement got a little contentious. I really didn't understand it because he paid the first $50,000 fine, and then all of a sudden he decided not to pay the rest, and I didn't really get it and know why he was doing that, because the parenting stuff didn't come up for like several months afterwards. So none of what he was doing made sense. I think he just got upset with Wendy or something. I don't know what it was.
Okay, thank you for that information. It wasn't contentious, but you did say that his motions were very personal. His pleadings were very personal.
That's where I think it became contentious, is
And
when he did that.
was that personal attacks on both Wendy Adelson and you?
Correct.
And he was alleging that Wendy Adelson committed fraud, right?
Yes.
He's alleging you committed
He
fraud.
did.
It got so bad that you had to get off the case so that you could be a witness on Wendy Adelson's behalf, right?
Correct. That's happened before, though. I mean, I've had that happen before.
And he alleged Wendy should be disbarred, you said.
Correct.
And he's having issues with Wendy's mom, Donna Adelson, even being able to watch the kids, is what you said in one pleading.
One of the pleadings said something about the right of first refusal that he had, and she shouldn't be allowed to have the kids unsupervised, I think, during right of first refusal, because she was saying things about him to the kids, he thought.
And did the litigation between Dan Markell and Wendy Adelson continue even after you got off the case?
Once I got off the case, it was the end of June, and I think that he was gone within a few weeks after that.
So you were
Yeah,
supposed to be
super
a witness
rambling.
on Wendy Adelson's behalf, right?
Correct.
Were you ever able to have that hearing?
No,
Why not?
because I got a call from Jimmy Jenkins when I was in Tampa at something that he was dead. It was pretty shocking.
Does that happen very often in your divorces?
That does not. We've had a few people get murdered, and I've had a few suicides,
Okay.
but it's rare. And I remember all of them.
Right, but not contentious.
Wow.
Sometimes I don't know with the suicides. I don't know.
That's all.
Thank you.
Redirect examination.
Briefly, Your Honor.
To say it wasn't particularly contentious and the man ends up dead, it's kind of funny.
And first witness.
You may.
Ms. Adamson, I'm going to approach to show you. I'm sorry. It states demonstrative A, I think it's going to 1, page 441 of the demonstrative. And I'm holding 454. If you hold that,
Sure.
please.
Okay.
Is that
Okay.
is that the March 26, 2014, pleading that Mr. Markel filed.
It appears to be.
Can you turn to 454 that I had tabbed?
Yes.
And
What's
is
the
that
problem
prayer
with it?
for relief for that motion?
Yes.
Can you direct your attention to the portion that reflects my client's, Donna Adelson's, time with the children? Does that reflect that Mr. Markel was asking that my client's unsupervised time with the children not interfere with his right of first refusal?
I think you're talking about paragraph 6, where it says, enjoin the former wife from allowing the maternal grandmother to have unsupervised time with the children consistent with the right of first refusal. That was that right of first refusal.
Yes.
And to impose appropriate limitations to safeguard the children from being subjected to disparaging comments about their father.
And this is helping Donna how?
Ms. Adamson, did you testify that the divorce was not contentious, but some of his pleadings post-divorce were contentious?
I think that's accurate.
Okay. And that his pleadings were personal. He essentially he attacked both Wendy Adelson and yourself.
Correct.
Okay. Is that what caused you to withdraw?
I'm very used to personal attacks. I've had a lot of personal attacks. The only reason, and I'm fine with that, the only reason that I withdrew is because I was going to be a witness, not because I cared what he said about me.
Had Mr. Markel not included in his pleadings these attacks, would that hearing have gone forward in May of 2014?
If he had not included personal attacks against me that I would have had to testify about, then I would have continued with the hearing.
Now, I want to go back to relocation. After the relocation hearing, my client, Donna Adelson, appeared to accept the court's ruling. To you.
As far as I know.
You don't know what she said privately, do you?
I do not.
Well, we know now.
Concerning Wendy Adelson's involvement in drafting of pleadings, I understood your testimony on cross to be that you'll take input from clients, but ultimately you're the one who is drafting the pleadings.
I take responsibility for my pleadings, and I've never filed a pleading based upon what a client told me I have to do. I will take input because I don't know all the facts. Sometimes I need more facts from them so that I can do it, but I'm ultimately responsible. My name's on those pleadings.
And so you're not going to cut and paste from what a client sends you?
Well, sometimes if they send me really good facts, I'll sort of go, oh, these are good facts, and then I'll take the facts and I'll put them in, but not legal arguments or anything like that, no.
So if you took facts that were provided to you by Wendy Adelson and put those in the factual statements or arguments concerning pleadings or memoranda, the law is still your own writing.
The law is, and I don't really think Wendy, I don't remember that Wendy had much input into any of it, honestly. She wasn't that client. I have clients that are those clients, and she was not that client. I get a lot of ChatGPT now, a lot, telling me what I should be filing.
I don't think you're the only one there, ma'am.
You taking shots at his client?
Had you not withdrawn to be a witness, the motion would have been heard in May of 2014.
May or June, whenever it was set. I don't remember exactly when it was set.
Okay,
Whatever the docket says for whenever it was set, yeah.
So if the docket reflects, I think it was May 15th of 2014, the hearing would have gone forward.
Correct.
The judge would have been able to make a decision on all the pending issues.
I believe that's the case.
Nothing further?
Will this witness be recalled?
Just a moment. We'll retain her, but she's free to go about her business.
Thank you.
You may step down.
Guys, I don't know. Again, any reasonable doubt when it comes to a motive for Donna? Any reasonable doubt when it comes to a motive for Wendy in that sense? Not seeing it at all. Let's keep it moving. Get this next witness up here. We might have a little bit of a break.
Your Honor, the next witness is Linda Bailey. She could be quite lengthy. I don't know if Your Honor wants to take a brief break. Jurors need one.
Do any of you need to take a break or use the restroom? Please raise your hands. A very equivocal wave, but I'll take it. The bailiff will take you to the jury room.
All right, so we're gonna skip ahead here.
Resume at 10:05.
Judge Everett, let me see. So we have
an exhibit from the state which detailed all of the pleadings in the family law folders.
I don't really want to go through these outside the presence of the jury hearings because we're looking at this as a jury, and they're not going to see this. So let's go ahead and get back into it.
The testimony of the challenged witness was substantially affected.
Here we
by
go.
the testimony
Back into
that
it.
The witness heard, to the extent the witness's testimony differed from what it would have been had the witness not heard the testimony. And this is citing to a Florida Supreme Court case, Steinhorst versus State, 412 Southern 2nd 332. The same test also applies to expert witnesses who violate the rule. Concerning the proffer, the witness has indicated that in preparation for her testimony, she reviewed materials provided by the state. She reviewed testimony from the same witness from prior trials.
Oh,
and ultimately
no.
Her opinions, whatever they may be, to be offered, have not been affected. As a member of the bar, I am going to give credibility to what Mrs. Bailey has stated concerning these matters, as I have no other evidence to the contrary. Although the state has asked for exclusion of this witness, this being a second violation, it still remains an
Wait, who was the first one?
Concerning how the jury is to be instructed at the end of the trial, as to this testimony specifically, if the state is asking for instruction for how the jury is to weigh the credibility of Ms. Bailey or the previous witness who is subject to the rule of sequestration, I believe they are entitled to based on the circumstances of this matter.
Wow, so we got two witnesses that were sequestered, and they're like, I want to see what ClassE's talking about over there. I'm gonna go watch their YouTube channel. Come on, man. They should know better.
Party need to be
Dang. This is insane.
As long as the instruction that the court is going to give, the state's going to specifically be asking for, ask the jury to determine
Wow.
whether the witness's testimony was impacted by what they observed.
We can wrangle over the language at a later point.
I have no objection as long as we can agree on the lecture.
Oh, you know the
Jurors,
state's gonna bring
Ms.
it up.
Bailey, please come to the witness stand.
Wow, Miss Bailey, what were you doing?
If there are any additional matters that need to be clarified, this needs to occur so we don't have any more issues with witnesses or other problems.
Wow. Wow, wow, wow. Let me see if there's anything else. Here she goes. Y'all are asking what happened. So this witness we're going to hear from, Miss Bailey, she was sequestered. So she was told, hey, you can't, like, you're not allowed to check out any information that has to do with this case. She was over here watching the ClassE Beats YouTube channel. All right, the ClassE YouTube channel now. She was in the chat. All right, and she was reviewing information from previous testimony, previous trials. And she's not supposed to do that. Lord. The Honorable Attorney Kelbell said the witnesses were willing to lie. You think they wouldn't listen? You think they would listen to the sequester order? Nope.
Ms. Bailey, please rise to be sworn. Do you swear or affirm the testimony you're about to give will be the truth?
I do.
You may take your seat. You may examine as you're ready.
Thank you, Your Honor.
Come on, Miss Bailey.
Good morning. Can you please introduce yourself to the jury?
Yeah, my name is Linda Bailey, and I'm a family law attorney here in Tallahassee.
And
And she's an attorney?
Educational background.
My post-high school educational background is I have a bachelor's in psychology from Florida State University in 1983. I worked for a couple of years and went back to law school in 1985 and graduated FSU Law in 1988 with honors.
So math isn't my strong suit, but that's
37 years.
37 years.
I went to school with Miss Adamson, so we've been practicing the same length of time.
What type of law did you initially practice when
Interesting.
you
When I initially, during law school, and then after I graduated, I initially practiced criminal defense law. Then I brought in slowly a family law practice. And then in 1994, about 6 years into practice, I shifted my focus to solely family law and went on my own and opened my own practice.
So since 1994, have you exclusively practiced family law?
Yes.
Can you tell the jury approximately how many family law cases you've handled since then?
Oh, I tried to count those for this trial, and my best guess would be around 2,000.
Do you have any certifications?
Like Kristen, I am board certified in marital and family law, and what that requires is an application that's about 3/4 of an inch thick that details all of your trial practice, litigation practice, the type of cases you've handled, how many experts you've done direct exam with, cross-exam with, etc. Then once you provide your application, the bar does a peer review, and that includes sending very detailed questionnaires out to opposing counsels and judges in front of whom you practiced. And then based upon that peer review, they will invite you to take the exam. The exam is a 6-hour exam done in Tampa, and I think the year I took it, 41 people sat for it, and I think 9 passed. So it's a pretty rigorous process.
Okay, before we continue, the clerk had asked me to have you spell your name. Can you spell your last name, please?
Yeah, Bailey.
Thank you. How many board-certified family law attorneys are there in the state of Florida?
I believe there are about 274, according to the Florida Bar.
Okay. And do you know what
that
percentage
number
of
ready to
lawyers
go.
in Florida are board-certified in marital and family law?
I think less than 1%.
What do you have to do to maintain your certification?
Well, ordinarily, lawyers have to do a 30 hours of continuing education every 3 years. To maintain your board certification, you have to recertify every 5 years, and you have to do 75 hours of continuing education every 5 years. So there's an enhanced legal education, continuing education requirement. And then you also have to continue practicing in the area where you have a certain number of trials of a certain length of time that you also have to do within that 5-year recertification period.
And you have to
and they also send more peer reviews out every 5 years. So all of the other opposing counsels, other board certified lawyers in your community get a questionnaire, and they get to fill that out about their impression of working with you, and that goes back for your recertification.
And judges also get that same peer review?
They do.
Do you have any other certifications?
I'm a Supreme Court certified mediator, and that was probably the mid-aughts, 2006, 8, I can't remember exactly when that was.
What's required to be a certified mediator?
It's a 40-hour course. I went to Orlando Monday through Friday, and then after the course you do co-mediations with other mediators, and then you have to do some supervised mediations, and then you're certified. They have the same recertification period, not as enhanced as a board certification, but you do have to take enhanced continuing education that might be a little bit different than you do for either your bar license or your board certification.
Have you maintained your board certification since you were first certified in 2011?
Yes, I have.
Have you received any other recognitions during your career?
Well, U.S. News and World Report puts out a Best Lawyers in America publication annually, and I've been recognized in that publication for many years. I'm not sure how many. They've also recognized my law firm as Best Law Firm in America, and recognized me as a woman in the law to watch. I also have been recognized as a super lawyer, which means the U.S. News and World Report bases their recognitions on peer review, and the enhancement at the super lawyer is it does peer review. It also looks at your practice, your certifications, your outside legal interests, like have you provided presentations, have you taught, have you done certain community service or pro bono work, that sort of thing.
Have you taught?
I have. I taught for several years. I'm going to estimate 5 years with the Legal Aid Thunderdome program. And that's really an incredible program where family law attorneys, now it's grown to do other disciplines, but at the time I was doing it, it was strictly to teach other lawyers who don't do family law how to do family law well enough to provide pro bono services, free services for people who can't afford lawyers. And my focus in that area of teaching was parenting plans, parenting schedules, relocation, those sorts of parenting-related issues.
Your Honor, we would tender the witness as an expert in family law proceedings.
Does the state wish to voir dire the witness as to their training or experience?
No, Your Honor.
Any objection to her ability to provide an opinion in the fields of marital or family law?
No, Your Honor.
Members of the jury, the witness will be permitted to provide an opinion while she testifies in the areas of marital and family law.
Thank you, Your Honor. In conjunction with your being retained as an expert in this case, can you tell the jury what materials you reviewed?
Yes, my primary source was the divorce file between Wendy Adelson and Dan Markel. So everything from the petition that was initiated in September of 2012 by Wendy Adelson to the last document filed, which was, I believe, a suggestion of death.
And did you review any other materials?
I reviewed text messages that were provided to me. I believe they came through the state between Wendy Adelson and Dan Markel in the 2014 timeframe. I was provided, but didn't review thoroughly, text messages between Wendy Adelson and friends and other miscellaneous texts. There were some text messages between, I believe, her and her mother, but most of their communication, I think, was by email, and I reviewed the emails that I was provided between Wendy Adelson and Donna Adelson from maybe 2011 up through about 2017. I don't know if they were comprehensive because they were provided to me.
Did you also speak with Ms. Adamson concerning her representation of Wendy Adelson?
I did. I spoke to her for about an hour a couple of weeks ago to kind of confirm my impression of some of the motions that were filed.
Okay. Now, can you indicated that you reviewed the court file. When was the dissolution of marriage action begun?
It was begun with a petition filed actually by Wendy, where she had a lawyer, Shannon Novi, for a brief period of time, and then she switched to Kristen Adamson. So I reviewed that petition, and that was filed mid-September 2012.
Did Wendy Adelson, in that process, file a motion for the court to determine a temporary parenting schedule?
Yeah, just about a month after the initial petition, she filed a motion for the court to order a temporary parenting plan, which is normal, so you don't have chaos pending a final resolution.
So that the filing of that motion is a typical step in a dissolution of marriage that involves children.
Well, it's very routine because what you don't want is both parents showing up to school, picking up the kid on the same day, and the kid doesn't know where they're going, and it creates a lot of stress for the children if they don't have a plan. So it's important for the parties to get together early on and figure out what they're going to do until the court can make a final ruling.
And what specifically was Wendy Adelson's request in that temporary parenting plan concerning time sharing?
She asked for a plan that would provide 51% of the time to her and 49% to Mr. Markel, which at the time, it was much more traditional, if you will, for there to be a primary parent and a secondary parent, and it was thought at that time that having a child more solidly in one household versus splitting the 50-50 was more advantageous for the child. That thinking has now changed, where there's a presumption of 50-50, but back in 2011-12 time period, she had initially filed for majority time sharing, which was ordinary, but then actually in her motion for temporary parenting, she asked for a 59-41, which is 51-49, which is essentially 50-50.
Why would one party ask for 51-49?
Really, the only reason I can think of would be for an IRS tax advantage, so you'd be able to claim the children on taxes.
To claim them as dependent?
As dependents, yes.
Okay. Or head of household?
Yes.
Okay. Now, you indicated that a lot of times these issues, it's important to establish them early on. Did Wendy Adelson and Mr. Markel have to go in front of the judge to get a temporary parenting plan put in place?
No, they worked that out by themselves, or through counsel.
So they worked out an arrangement that was beneficial for the kids and allowed them to have time sharing?
Yes, my understanding is they worked out a 50-50 arrangement.
Okay. Now, we're using the term time sharing. We also have, during the trial, heard the term custody. Historically, has the term custody been used in family law proceedings?
Not for many years. Not for many years. Gosh, it may have been a term back when I started practicing, but then it went to primary residence and secondary residence, and then it moved to simply time sharing. So there's been a change in way we refer to it linguistically, because you don't want a secondary parent. You want all the parents to feel like they're full parents. So.
Okay. And so the term custody is not something that is used in family law proceedings any longer?
Not between parents. There's some, the term custody still lingers in some grandparent cases, which aren't applicable here.
Okay. But when we're talking 2012 moving forward, the term custody was not used in family law proceedings for dissolution.
Correct.
Okay. And the term at that time was time sharing and parenting time.
I believe back then it had shifted to time sharing. It may have been primary and secondary residence, but I didn't see that in the petition. She just asked for majority time sharing, so that must have been when that law switched. It was around that time.
When Wendy Adelson initiated this dissolution, did the pleadings indicate that she was trying to prevent Mr. Markell from having substantial time sharing?
No, I didn't see anything throughout the whole file. She tried to prevent Mr. Markell from having substantial time sharing.
Can you tell the jury what is substantial time sharing?
Well, substantial time sharing, again, the definition has changed. It used to be more, in this era, it was more than 40% time sharing. And now, for the purposes of child support adjustments, it's kind of been reduced to 20% or more. But I think when we're talking about time sharing versus how it impacts child support, substantial time sharing, I think everybody would accept would be 40% or more time sharing.
But again, this looks bad on Donna, because if they're saying Wendy had things were going smooth, things were going great, it makes Donna look worse to me, doesn't it? Seems like Donna, she was fighting, she was going about the legal way, there wasn't too much back and forth, but Donna was the one behind the scenes saying, hey, we got to play psychological warfare now. What? I don't understand, man.
So, in other words, when Wendy initiated the dissolution against Mr. Markell, she was not trying to prevent him from having 40% or more of the overnights.
I never saw anything other than the 49-51.
In your review of the family law pleadings, can you tell the jury how many contested hearings took place prior to the final judgment being entered?
From my review of the pleadings, one partial hearing occurred, and that was the June 21st, 2013 hearing on Mr. Markell's motion to dismiss the petition for relocation, and then he had filed a motion to enforce life as he would have liked to have seen it.
Oh my.
And then the relocation was all within one hearing. The court adjudicated the first two issues. His motion to dismiss was denied. His motion for enforcement was denied because there was nothing to enforce. There was no court order that required the things he wanted to enforce. And then...
In other words, he was asking the court to enforce something that they had agreed on but hadn't been a court order?
Well, I don't even know that they had agreed on things. He had kind of a sense of the way he would like to see life, which had to do with being really intrusive at Wendy's home. He wanted to go over there often during her time sharing. He wanted to have a great deal of contact. He wanted video contact, things like that. And so, and I think there was maybe a recommendation, I could be confusing this with a later motion, where the child care owner had made a recommendation about something and he wanted to enforce the recommendation from the owner of the child care. None of those were enforceable because they've never been ordered by court or even put into any sort of formal document. So that was denied.
So let me understand correctly, he was asking for court authorization to be able to go over to Wendy's house?
In that particular motion, I can look at my notes, but I don't remember exactly the detail. Ordinarily, when you file a motion for enforcement, you have a court order that says the other side has to do A, B, and C. And if you don't do A, B, and C, you file a motion to enforce. But you can't enforce an email communication back and forth where you said, you know, you can have them on Tuesday, and then Tuesday you change your mind. There's no court order to enforce. They just change their mind. So he was trying to enforce conversations that he had had with Wendy that had no court-ordered basis.
Okay. Now, you mentioned the motion, Mr. Markell's motion to dismiss the petition for relocation, his motion for enforcement. Was that also the same hearing where the relocation petition was heard?
The same hearing.
Okay. And based on your review of the file, what happened at that hearing?
Based on my review of the file, the court adjudicated his motion for enforcement and denied it. adjudicated the motion to dismiss and denied it. And he was basically saying that the petition for relocation was baseless and that the court should deny it. And the court said, no, it had merit, so we're not going to dismiss it. And then my understanding is before the hearing finished, Wendy essentially capitulated and said, okay, I'll agree to the denial of my relocation. And what's consequential about that is if they could have continued the hearing, finished their testimony, and appealed the order. So by her capitulating and stopping the hearing midway, she waived her right to appeal the denial of the relocation.
Subsequent to the June 21st, 2013 hearing, did Wendy Adelson and Mr. Markell resolve the other issues in their dissolution of marriage?
Yes, on July 31st, they signed a full marital settlement agreement that addressed all issues. So within 5 weeks of the denial of relocation, they resolved all their financial issues. Wendy waived alimony. They adjudicated child support. They put into place a parenting plan, which is kind of also new lingo. A parenting plan is kind of the overarching rules on how you make decisions, how you communicate, who's able to go to events for the children, plus the time sharing schedule, plus communication provisions, how often you can speak to the children. Sometimes, like in this case, it was very general language, maybe what school the children go to. So they resolved everything 5 weeks later.
Now, the marriage settlement agreement also put in place a parenting coordinator?
It did.
What is a parenting coordinator?
A parenting coordinator is a professional, generally a lawyer, but it can be a therapist who is trained. I think they do a 40-hour course too, but I'm not certain. And they have a certification. And what they're trying to do basically is teach people how to communicate, teach people how to be reasonable. There's no parenting plan that you can draft that deals with all contingencies. People are always going to come up with something, and we don't have a provision in the marital settlement agreement to deal with that. So a parenting coordinator helps people set, for example, communication guidelines. Maybe one person is calling 10 times a day, and that's overbearing and it interferes with the other parent's life in households. So a parenting coordinator may help them reach agreement on what a reasonable communication might be. Maybe it's once a day at 7 o'clock. Maybe it's every other day. Maybe it's 2 times by video and 4 times by telephone or something like that. So they help them work out the details and just keep the conflict low.
Now, can a parenting coordinator put in place provisions in parenting plan that are not already included in the marriage settlement agreement?
No, the parenting coordinator's role is to help the parties have a civil discussion and come up with a reasonable resolution. But if there's no reasonable resolution that they accept from the parenting coordinator, then they can go to the court and ask for a remedy in certain circumstances.
In certain circumstances?
Yeah, for example, the parenting coordinator is not permitted
we're just
to
talking
add
about
provisions that
family
are not in
law
the marital
right now.
settlement agreement. In that circumstance, you can't just go to the court and say, hey, I want this provision added. You have to file a supplemental petition that requires a material and substantial change in circumstances, plus best interest. Kristen talked about that earlier. And you have to, it's basically starting a case over. It's very difficult to modify a marital settlement agreement. What you can go to the court.
She said Kristen talked about that earlier. This sequestration order in place. Oh my God.
The parenting coordinator might be involved in if somebody's not returning the child on time chronically.
Y'all hear that?
Or violating communication provisions that are already in the marital settlement.
My friend
agreement.
talked about this
You may go
earlier.
to the parenting coordinator first to try to avoid court and say, hey, can you get her to stop? Can you get them to be more timely? Can we find a new meeting location, something like that? And you can go to the court for those types of issues, violations, but going to the court for modifications isn't going to happen unless you've had a material and substantial change. And the case law says that has to be an extraordinary change. So it's very difficult to get a modification or add terms.
Now, with respect to the Adelson-Markell case, other than that June 21st, 2013 hearing, were there any other, did they litigate any other issues?
During the divorce?
Yes.
Up through July 31st?
Yes.
No. No, they resolved everything. Temporary parenting, permanent parenting, support, property.
How many months elapsed between when the petition,
I cannot wait to hear these
initial
closing
petition for
arguments.
dissolution of marriage was filed and when the final judgment of dissolution was entered?
10 months.
How does that compare with cases that have similar issues?
If you take the relocation issue out, it's probably average. If you add the relocation, it was brief. Most relocation cases take 2 years or so to get to trial.
As of the final judgment of dissolution on July 31st, 2013, would it be your opinion that this case was in any way unusual or highly contentious?
No, to the contrary, it was settled amicably, and everybody was moving on with their lives.
And quickly?
Yes.
During the underlying litigation, so between September of 2012 and July 31st of 2013, when it was when the final judgment was entered, did either party file a motion to compel against the other?
No, and what that is if you're upset with the other side because they're not providing either the required financial documents that Ms. Adamson spoke out earlier, or if you do a request to produce more documents and they don't comply, then you would file a motion for the court to compel them to provide those documents.
And that's what we call discovery.
Correct.
Were there discovery fights here?
No, there were no discovery fights. There was afterwards when Mr. Markel's lawyer was trying to depose Wendy about the money he had not paid, but prior to July 31st, there were no discovery fights at all. There were, I think, requests to produce, and there was no motion to compel or any complaint about responses to those. I didn't see any third-party subpoenas to banks or holding companies or brokerage accounts or brokerage companies.
Can you explain to the jury what a third-party subpoena is?
Yeah, so for example, if you believe that a party has an asset that they're not disclosing, and if you know, in general, sometimes we do kind of blanket ones, but generally if you know where those documents might be held, whether it's Fidelity or Wells Fargo or Bank of America, then you can do a subpoena. You do a notice first, and then you have to wait 10 days, and then you can issue the subpoena directly to the bank or the person holding those records and ask them to provide you the records directly, so you don't have to get them from the other party. So sometimes we'll have parties who just don't cooperate. They don't provide anything. We know they have retirement accounts. I have one right now, and he will not give us his retirement account because he does not want it split. So we are having to send third-party subpoenas out to all his prior employers to get his retirement records because he's just not doing it. So it's an easier way to get those records than fighting him directly.
And so in that type of scenario, you'd have to first subpoena his records from prior employers in order to get the names of the retirement companies, correct?
If I need to do that, they could be company-held employment plans, depending on what kind of company, you know.
But potentially in that scenario where you're having to issue third-party subpoenas, there are multiple layers that you might have to go through in order to get the information that the other party is not providing.
No, it's really more direct than that. I mean, once you file your notice of intent to subpoena a third party, you issue your subpoena to that party. The difficulty comes if you don't know who the party is. Then you might have to take a deposition and find out where somebody's been working. Generally, your client knows where their spouse worked, so you have that information in that example. But there could be, like we have a case right now where there's like 140-something real estate properties all over the country. And that makes it more difficult, obviously. So we're having to go into databases all over the country in different states to look for people and then find out who the management company is and then third-party subpoena the management company. But that's
Okay, yeah, whatever. I mean, we still don't know what this has to do with Donna. Just a lot of family law talk. This is what's going on. This is what happens in the family law case, blah, blah, blah. Let me know what y'all think about this in the comments in the chat. Y'all, what is this defense doing? I don't know. Shout out to everybody that's in here. Over 1,200 of you in the building, and nearly all of you have liked the video. If y'all haven't yet, please like the video. I would greatly appreciate it. I don't see how this is making Donna look any better. We got a couple super chats I want to get to, and then we're going to get up out of here. We've got Mayflowers in here. Shout out to Mayflowers, says, to the best channel with the best trial coverage. Thank you, Mayflowers. I appreciate that. And thank you for the support as well. We've got Dottie in here. Amazing Grace was in the building, dropping the 3-bomb, giving the kisses. I'm giving them all back to you, Grace. I love you. I appreciate you. Thank you for the support and for the love, as always. We've got my guy, Mr. Brown. It's Mr. Brown's birthday, y'all. Spam happy birthday to my guy, Mr. Brown. Praying for you, man. Hopefully you have an amazing happy birthday, and may God bless you with many, 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 many more. So glad you're here with us. Glad you get to celebrate. I'm excited to hear how your birthday goes, man. Thank you for spending it here with us. That's dope. And then, of course, Amy, y'all know what time it is. She's dropping the cake in the chat. She got all the cake over there. She say I have promises to keep. Happy birthday to Mr. Brown. Thank you to Amy for that super chat, and all of y'all as well. You know, we're going to be back here and try and figure out what's going on with this case from the defense. Hopefully we'll get somewhere with this. We're going to continue the rest of this testimony from this this family law attorney. Y'all make sure you stay locked in. If you haven't yet subscribed, hit the notification bell so you don't miss any time that we go live. We will be live tonight for another episode of Song the Night Live. So if you love hearing music from independent artists in this community, make sure you tune into the show tonight. Hope y'all have a great rest of your day. And as always, you know what to do. Keep growing, keep pushing, keep it classy. We gone. Peace. Man, defense is garbage.